My lord, grant me leave to mention, my lord, one urgent section 9 application, my lord. Respondent, my lord, took forcible possession of my loaded vehicle from the road. My lord, I understand, my lord, they are going to sell out the property, my lord. And as a file is yesterday, this application is filed yesterday, but the file is not here, my lord. I want to move the application at any early date, my lord. If grant me leave, my lord.
Where's the other side? Notice?
Other side, they have not lodged any caveat, my lord.
But you have to serve them a notice.
My lord, if they receive the notice, my lord, they create third-party interest, my lord. This is the problem, my lord.
So this is what? A financial institution?
Yes, my lord.
You are moving against a financial institution?
Yes, my lord.
You have not paid your EMIs?
Some dues, my lord. Till paid up to June, my lord, paid. I have received, my lord. The next due is 3rd August. As per their letter.
Ex-party section 9, I don't encourage.
My lord,
you have to serve them a notice.
My lord, they have, if I serve, my lord, they have create third-party interest.
All right, we'll see that. If you have any right, we can always reverse it.
All right, my lord, I have served notice.
Serve notice and mention it.
And I have to appear on.
First serve notice and then mention it.
Yeah. Lord, may I be permitted to mention to execution matter for withdrawal? Yes.
Yes.
I know one. My lord, in this matter, I am led by Mr. Alim. He is on division bench on his legs, my lord. If this contempt could be, my lord, placed at month of November, it can be hard.
This is that matter where settlement was going on. They had not signed. Now they have signed the agreement. They have even accepted the post-dated check.
Then what is
the post-dated check, my lord? That is yet to be paid, my lord. Once
not original is with them, my lord.
No, original. I am holding the original one, but my lord, they have accepted that only with the realization of full and final settlement, it is to be withdrawn.
The last page.
My lord, kindly come to para.
The check, the post-dated check has also been received by them.
My lord, kindly come to my lord.
5 lakh was the due amount, 4 lakhs paid, 1 lakh post-dated check as per the terms of the agreement. Not everything has been done. Not the
my lord, kindly come to.
That is the only issue.
Lord, this check.
Check is of October.
October, my lord. If my lord, it can be placed at November.
No, not at all. Nothing survives. You can always come back. Next week or Friday, we'll finish it off. The point of
7th August.
7th August.
7th.
No point keeping matters pending. No, 7th August. Wait a minute. 5th August. 5th. Keep it on next week.
5th August, man.
5th
August.
Not today, 5th. We'll finish it off. We are not going to wait.
My lord, I was just seeking.
You have a right. You can always come back to the court.
Very good, my lord.
Don't burden the court unnecessarily.
My lord,
5th.
Not two.
May I please,
my lordship?
Finally, my friend is appearing. I have served him thrice.
I'm being led by Mr. Shomaba Mukherjee. My lordship, I'm praying for accommodation for the day since he's out of
the formal extension. The last extension was filed by him.
Extension.
My lordship, I'm opposing the application.
What ground?
For.
I don't know. What ground are you opposing the application? Just the extension.
My lordship, for extension of time.
Why are you opposing it? Give me the ground on which you're opposing.
My lordship, the arbitral award has not been pronounced in appropriate time.
So that is the reason why we are giving the extension, so that it can be pronounced.
My lordship, kindly keep the matter on next Monday. It would be kind enough.
Why? Why you're not prepared today?
My lordship, my senior, I'm being led by Mr. Shomaba Mukherjee, and he's out of town, out of station.
Tell him to join virtually.
My lordship, if your lordship so please, it would be kind enough that he will be able to join virtually at around 2 p.m.
I'll dismiss it. Record your submission. We go by the dictate of the lawyers.
My lordship,
that he'll be free at 2 o'clock and 3 o'clock, and we should wait for him. Where's your file? Why you have come to the court without the file? Have you come here for a picnic? Is there a garden? What have you come here for? Where's the file, sir? Where's your file? How can you appear in the court without a file? You are appearing in this matter. Where's your file? Where's your file?
My lordship,
How can you appear in a court without your brief? Why should we not refer you to bar council for inappropriate behavior? What have you come here for?
lordship, I came here for
To assist the court? To appear for your client? Where's the brief? Where's the brief, sir? Why you're not carrying your brief? I will still grant you an adjournment, but where is the brief? How can you appear in a court without a brief?
My lordship, I apologize for this.
How many years in practice?
My lordship, I recently joined the
So this is what you're learning, that you should appear without a brief. Even if you have to take a Passover, you should come with a brief. Don't do it again. Yes.
Millets may have it. Otherwise, Millets, the last extension was filed by them only. I don't understand what is the objection.
No objection unnecessary. Monday.
Monday. Millets, I have already filed the affidavit of service, Millets, since they are appearing.
They're appearing. Monday.
Monday.
Back on Monday. And don't appear in any court, not only my court, without a brief.
I'll agree. 2 and 3 are connected, Millets. Connect.
Lordship, this is my application under section 29A on the last occasion. There was a defect in an affidavit of service. We have rectified it. This is for both?
No.
This is for- The proceedings were marked ex parte initially. Thereafter, we had filed a section 29A. At the time, Your Lordship, there was a debate. Our view was that under 29A, after expiry of mandate, you cannot file for extension. Went up to Supreme Court with HON'BLE. Thereafter, the Supreme Court said that since the matter was already ex parte, and despite that the award was not passed in time, the Supreme Court was pleased to terminate the mandate and remanded back to the High Court for appointment of a fresh arbitrator. On 7 January 2025, a fresh substitute arbitrator was appointed. Proceedings ex parte. Thereafter, Your Lordship, I must point this out, only 3 sittings have taken place in the past 12 months. The 4th sitting was after the expiry of mandate. There are 2 connected matters, both 4 and 5. Both were being held analogously. Arguments for one was completed, that too on the 4th sitting beyond the expiry of mandate, and the next one has not been taken up. So, Your Lordship, I have filed an application for extension of mandate, but I shall leave it up to Your Lordship. If Your Lordship feels, then Your Lordship will kindly exercise his discretion rather, for substitution of an arbitrator. Otherwise,
No substitution. Yes. Any other time?
he is with me.
Who's on the other side? Yes.
Lordship, it is ex parte, yes. They have not been appearing.
Take off. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for completion of the arbitral proceedings and publication of the arbitral award. Full stop. This court, by order dated 27/9/2021, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 3/3/2022. Full stop. Since there was no extension of time by the consent of the parties, the petitioner approached this court for extension of the mandate of the arbitral tribunal. Full stop. This court, by order dated 30/8/2023, dismissed the said application, and hence the petitioner had approached the Honorable Supreme Court. Full stop. The Honorable Supreme Court, by order dated 23/10/2024, allowed the said special leave petition and substituted the earlier arbitrator by appointing a new arbitrator to adjudicate the dispute between the parties. The respondent, full stop. The respondent failed to appear before the new arbitrator and the matter has proceeded ex parte. Full stop. In the first matter, arguments have been concluded.
Yes. Your Lordship, the arguments were concluded beyond the mandate. I must point this out.
That's all right.
Only the first matter.
Only the first. The argument was concluded and award is to be pronounced. Upon consideration of the material placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the learned arbitrator is extended further for a period of 3 months. 3 months from today.
Will grant 6 months since both one award and the other argument. So
in the second one, I'll pass a separate order.
very
Both of
very
them.
well.
Item 4 में ये है 3 months from today. The learned arbitrator is requested to publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed of. उसके बाद second वाला order करना, उसमें से जहाँ लिखा है ना, arguments have been concluded. वहाँ लिखना, learned counsel for the petition states that the arguments are going on, right?
Have to begin for the second one.
Learned counsel for the petition states that it is at the stage of arguments. उसके बाद कर देना, बाकी करके 6 months.
Your Lordship will kindly record affidavit and service in both the matters.
Affidavit of service is taken on record.
Grateful.
Despite service, none appears for the respondents.
Great.
Respondent or respondents?
One. Respondent.
Okay. Dates are the same, right? Supreme Court order, everything is
Yes,
the same.
yes. The orders are all the same date. Yes.
My lords, my lord, we are praying for an application for extension of the time for the arbitration to be completed, my lord.
Who's on the other side?
Affidavit.
Are they appearing before the arbitrator?
Yes, yes, my
Where are they?
lord. My lord, if I may go through the timeline with my lord. Yeah. My lord, an email was also sent yesterday.
There's only one respondent?
Yes.
Yes. Okay. Yes, give me the timeline.
Yes, ma'am. So, my lord, the pleadings were completed on 6th
When
July
was the arbitrator
2020.
appointed?
Yes, lord.
Arbitrator
The
appointed
arbitrator,
August
29th August, 23rd August 2023.
23rd August
2023.
Yes. Pleadings completed on?
On 6th July 2024.
All right. And the first extension?
The first extension by consent was on 4th January 2026.
Till
Till 4th Jan. One second, sir.
5th January.
5th Jan. Yes, 5th January to 4th July, sir. The second. So first there was a extension by
July
consent. Yes.
2024, right?
Yes. Yes.
And then
Then an extension by an order in AP number 219 of 2025 from 5th January to 4th July 2026.
all right, that's court order. Okay. What is the stage of the proceedings?
My lord, the final sitting will be on 29th August.
No, what is the stage of the proceeding?
The final submissions will be made on 29th August and then it will be reserved for
Arguments-
award.
Arguments are going on.
Yes, yes, yes.
Take down. First paragraph same होगा. This court wide order dated 23/8/2023 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 6/7/2024. Full stop. Thereafter, the parties with the consent by mutual consent extended the mandate of the arbitral tribunal by 6 months. Full stop. Thereafter, this court-wide order dated 5/1/2026 extended the mandate of the tribunal by 6 months till 4/7/2026. Full stop. Learned counsel for the petitioner states that the matter is at the stage of final arguments. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the learned arbitrator is extended further for a period of 6 months.
6 months.
6 months from today, sole arbitrator is requested to conclude the arbitral proceedings and publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed of. Affidavit of service taken on record. Despite service, none appears for the respondent.
Much obliged, my lord.
This goes in item 678.
Yes, my lord.
Same.
Yes, my lord. There were 3 work orders, and therefore there 3 applications were filed, and same hearing is ordered.
Same order, huh? 6,
Yeah.
7. All the dates are the same, right?
Yes, my lord. All the dates are same.
All the matters earlier also on 5th of
Yes,
January.
yes, my lord. Yes, my lord. Absolutely. Much obliged, my lord. 8 days service.
Just give the service in all the matters.
I will be
6 and 7 we have given, and
within the 10-15 minutes.
15 minutes we'll give it, my lord. It's there with
It is
us.
there.
It is there.
It is already online, filed online.
6, 7 you have given, 8 you have to give. 8 you'll give.
So I will give it right now. I'll give it right now.
Yes.
9.
For the respondent of 4 and 5.
My lord, I appear for the petitioner, my lord. If my lord gives me a short passover, I am not the advocate on record, my lord. Mr. Rohit.
No, they can. They can. Milord, in this matter, I'm appearing on behalf of the claimant, Milord. Dispute arises out of a development agreement. Milord, this application is for extension. Now, Milord, the difficult part or the embarrassing part is, Milord, originally an arbitrator was appointed, then Milord, he released it. But he was there in session for some time. He released it. After that, Milord, we approached this honorable court under section 15, and this honorable court was pleased to appoint another arbitrator. Now, Milord, before the second arbitrator, we had the cross-examination of the respondent's witness. We also had the cross-examination of another witness of another respondent. But we had completely forgotten that the mandate had expired by that time. So, Milord, last year, in the month of May, it dawned upon us that the learned arbitrator's mandate had expired. This is the situation, Milord. But all the parties were present when the examination and cross-examination was being conducted. So if that can be considered, I can, Milord. I don't think so there would be any objection to that.
I'm for the respondent number 4 and 5. Milord, may I place, Milord, the relevant dates, Milord, once, Milord. Milord, on July 17, 2023, Milord, the pleadings were completed in, Milord, in respect of the arbitral proceeding, Milord. July 17, 2023. Milord, 1 year from July 17, 2023, Milord, comes to July 16, 2024, Milord. The arbitral proceeding has to be completed. Milord, no extension of the mandate of the learned arbitrator was sought for with respect to, Milord, the 6 months period.
So mutual consent, Milord, was not there.
Milord, on 28th February 2024, Milord, the learned arbitrator, Milord, the erstwhile arbitrator, Milord, recused himself from, Milord, the arbitral proceeding. Milord, why, Milord? Milord, several allegations were raised, Milord, against the, Milord, the learned arbitrator. Milord, this has been categorically recorded, Milord, in the, Milord, the order passed by this honorable court, Milord, in an application under section 1415, Milord, for substitution of the arbitrator, Milord. Milord, that, Milord, order is at page 15, Milord. Once, Milord,
They are not going to allegations.
no, Milord, may I, Milord, place the conduct, Milord? Why, Milord? Milord, the arbitral proceeding is, Milord, continuing since 2022, Milord. Milord, thereafter, Milord, after February 20, 2024, Milord, they did not take steps, Milord, for substitution of the arbitrator. Milord, after, Milord, expiry of a substantial period of time, Milord, they filed an application on section 14 and 15. Thereafter, Milord, by an order dated 28 February 2025, Milord, the learned arbitral tribunal was again reconstituted. Now, my lord, the balance period, my lord, this honorable court directed that the arbitral proceedings shall continue from the stage where it was, my lord, it was.
Proceedings will continue from the stage it was last held.
Yes, my lord. I bow down, my lord. My lord, therefore, my lord, thus, my lord, only 5-month period was, my lord, remaining from February 2025, my lord, for, my lord, the 12-month period. Now that expired on July 16, 2025, my lord. My lord, from July 16, 2025, my lord, the learned arbitrator did not have any mandate. My lord, now, my lord, may I place, my lord, certain pleadings, my lord. Various contradictions, my lord, is there in, my lord,
Lord,
the
may I make one
application.
humble submission? My learned friend was fully present when the cross-examination of his witness was being taken up. I am taken aback in this arguments.
Lord,
I am taken aback because he was equally unaware of the fact that the mandate has expired.
my lord, why, my lord, I am, my lord, making this submission is that, my lord, the arbitral proceeding is pending since 2022, my lord. My lord, the claimant, my lord, is, my lord, very, my lord, lackadaisical towards,
No,
my lord,
not at all. There has been two
proceedings with
commissioners
arbitral
appointed who had to visit and evaluate the property.
2025, there has been a substitution of the arbitrator.
Yes.
From 25, it's been going on.
Yes.
Sitting in 26.
Every
In
month,
the interval
every
of one
month,
period,
more
my
than
lord,
twice.
was, my lord, not, my lord, one period, my lord, was, my lord, expired, my lord, for, my lord, substitution of the arbitrator, my lord. And, my lord, the application was also filed, my lord, very
You know
late.
the law now. It doesn't matter at what
But
stage
I-
you're
I-
filing the application. All those things are in the past.
I
You can
bow
file
down.
the application at any stage.
My lord, kindly record my my lord, the objections and, my lord,
What objection? Tell me the objection.
Lord, this is, my lord,
Objection.
the,
What?
my lord, and, my lord, no, my lord,
What
the,
objection?
my lord, the conduct of the, my lord, the claimant, my lord.
Only the-
That's, my lord, I am, my lord,
Conduct of both the parties is that both the parties were jolly well appearing before the arbitrator, doing examination in chief and cross-examination.
Correct. Right.
There has been a delay. Not that case because the pleadings were considered in the mid of 2023 itself, and after 1 year there was no extension. So this thing, this delay may not should be reckoned from in the middle of 2024.
No, we are not getting into that because as far as 2025 order of 20th February is concerned, we'll take it from there.
And in by that,
Because that order is very clear to the extent that whatever the proceedings were at whatever stage, it will continue from that.
so will not know prayer for extension was made, even though the will not expiry have taken the
None of the parties have.
there is no point.
So you were there on 20th February. I don't see that being recorded in that order.
Pointing out.
And my lord, we are at the final argument stage. The lordship can, my lord, extend it reasonably so that we can conclude the final arguments and the award can be passed.
Take down. The petitioner has preferred the present.
Prayer it says that an order be passed extending the mandate of the school arbitrator with effect on September 16.
Lord, it would be July 17, 2025. This is a mistake, my lord.
that is, my lord, inconsistent.
This should be 27.
Yes.
We expect that in 2024 itself. Otherwise, the entire proceeding that has taken place, that will be without any mandate. Because going by the law, my lord, pleadings were completed in 2023. Means of 2023 July, it's an admitted case. After 12 months, my lord, there was no extension. So if there has to be any extension of mandate, that has to be from that date itself, not from March 2023.
No, my lord, the date would be first day, September 16, 2025 is an error. It would be July 17, 2025. July 17, 2025.
This has to be carried out.
That paragraph,
It can't be done like this.
And, my lord, various inconsistent,
you
my lord,
have-
dates are there, my
You
lord.
have to correct it, Mr. Bennett.
My lord, then kindly grant me the liberty to withdraw the application, file afresh. Because if I come up with an amendment application, it would take more
It
time.
will take time.
Yes.
Learned counsel for the petitioner seeks to withdraw the present application with liberty to file appropriate proceedings with better particulars in accordance with law. The present application is dismissed as withdrawn with liberty as prayed for. He is right to that extent.
Yes, my lord, only to that extent. I am deeply offended. নামটা দিন।
10, my lord, I am for the petitioner, my lord.
I appear for the respondent, my
But
lord.
may I file, my lord, my affidavit of service, my lord. Lord, this is an application from Lord for extension of mandate, my lord. Lord, to be very candid, my lord, this is the, my lord, the fourth extension, my lord.
Where's the last one?
My lord, the last one, my lord, was, my lord,
17
on
December.
17th of December 2025, my lord, at page 39, my lord.
39.
39, my lord.
Oh.
My lord, the stage of the, my lord, the arbitral proceeding is that, my lord, it's reserved for, my lord, award, my lord,
It's just for a publishing of the award.
for the publication of the.
No objection? All right. Take down. The petitioner has preferred the present petition under section 29A4 of the Arbitration Constitution Act 1996, seeking extension of the mandate of the arbitral tribunal for publication of the award. Full stop. This court-wide order dated
17 December 20.
8/12/2022 appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 27/3/2023. Full stop. Thereafter, with the consent of the party, the mandate was extended for a period of 6 months till 17/9/2024. Thereafter, by order dated 5/11/2024 and 26/6/2025, this court extended the mandate of the and order dated 17th December 2025. This court extended the mandate of the arbitral tribunal further by 6 months, 6 months, and 3 months, respectively. The learned counsel for the parties submit that the final arguments have been concluded and the matter is listed for publication of award. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 3 months.
3 months.
3 months, my lord.
Only
Three-
publication is remaining.
Publication.
3 months. From today, the sole arbitrator is requested to publish the award within the extended time period with the aforesaid direction. The present
Great.
petition stands disposed of. Affidavit of service taken on record.
Hello, I am for the respondent.
Section 11, Act number 11.
My lord, may it please your lordship.
Hello, I am for the respondent. I am praying, my lords, if the matter can be made or not today. My lords, I am being led by Mr. Banerjee. Some medical difficulties not attending court today. The pleadings are otherwise complete, my lords. If it can be kept tomorrow, my lords, we can.
Which Mr. Banerjee?
My lords, he has some medical difficulty. Mr. Abhishek Banerjee, my lord. He's in some medical difficulty, my lord. We'll come back tomorrow.
Take down. Mr. So and so, you are?
He's
What's
for the
your name?
respondent, your lordship.
Respondent, my lords.
Name,
My
name.
lord, Devdatta Mukhopadhyay.
Mr. So and so appears. Proxy counsel so and so appears on behalf of Mr. Abhishek Banerjee and states that Mr. Banerjee is indisposed, prays for an adjournment, that this matter be listed. When do you want? After 2 weeks?
My lords, can be kept on tomorrow, Friday.
Next week, if your lordship kindly allows. Tomorrow I have some personal difficulty, my lord.
Next.
Grateful.
Grateful.
Next week रहेगा, ठीक है? Judgments दे दो.
In this section.
My lord, I beg to appear for the petitioner. My lord, I have got hold of the registered deeds, my lord. Famous, sir.
May I be favored with a copy so that I can take
You
instruction?
have to file it. It's a supplementary affidavit. What are these registered deeds?
Your lordship will recall I had taken 3 points to this section 11. A, it is barred by limitation. B, the respondent number 2 is not a signatory. And C, that this arbitration app is not a binding arbitration clause. So they had relied on certain deeds which were unsigned. I had taken that point. So today they are producing the
So you file it a supplementary affidavit, bring it on record.
I shall.
Give it back. Learned counsel for the petitioner seeks and is granted time to file supplementary affidavit, bringing on record the conveyance deed
Yes, sir.
executed between the parties.
Lordship will not record parties because there are two parties.
Conveyance deeds concerned with the proceedings of this court. Within a period of
Within a week or 2 weeks.
within a period of 2 weeks.
Grateful.
Grateful, Your Lordship.
This one, 3 weeks, 4 weeks. Yes.
In my section 11 application, Lordship, there was a previous round of litigation. An award was passed by which one of the claims was awarded and rest were nil award. That was challenged by me, saying there was no reasons. Section 34 was allowed. Section 34 was allowed with regard to those claims which there was no reasons.
Yes.
That judgment is at page 243. And thereafter, section 11 was filed and it was withdrawn with liberty to file afresh. And this is the section 11 filed.
243.
243 is the section 34 judgment. Volume 2, I'm sorry.
Commercial Court, Asansol.
Yes.
What happened in the 34?
This is 34 judgment. This is the 34 judgment by which the award was set aside with regard to the rest of the claims in which there was nil award. And except one claim which was not challenged also. Lordship will see the page 258, Roman 8, para 8, towards the end. Roman 8. Having regard to the discussions made above, the irresistible conclusion is that except claim number 2, the learned arbitrator passed his award, which is bereft of any cogent reasons as required by the statute. Since the arbitral tribunal passed such award without assigning reasons as aforesaid, the award is in conflict with the public policy, and as such, the award deserves to be set aside on these grounds. 7. Except claim number 2. As a consequence, further discussions does not it's set aside. Now, after this, this was assailed before the division bench by the respondents, that was dismissed for default thrice. It has thereafter not been restored and no application is pending thereafter. A section 11 was filed. The first section 11 which was filed, a point was taken that a fresh section notice ought to have been given. In the affidavit in opposition, that point was taken. A fresh section 21 notice ought to have been given, although it was a point that no fresh section 21 notice is required. There are various judgments to that effect. But nevertheless, since the court said the point was raised, we gave a fresh section 21 notice and liberty was granted to file a fresh section. And this is the section 11 application. That liberty is at, Lordship will see page 260. Second volume, 260.
Yes.
It is submitted by the notice under section 21 has been issued on 12th December, but the respondents have not yet taken any steps. However, the period is not yet over. Under such circumstances, the application dismissed as withdrawn with liberty to file afresh after expiry of the period as mentioned in the statute.
Yes.
The fresh section 21 notice at page 261. last paragraph at page 264, I have indicated, although an invocation, I'm sorry.
Yes.
Although an invocation notice is required to be sent once the disputes are still not resolved, the first invocation notice sent on 31st July 2015 should suffice. Yet for abundant precaution, this instant notice is being sent for the ends of justice and sufficient compliance. My claims remains the same. My what was before the learned arbitrator in the first occasion remains the same. But since this point was taken that a fresh 21 notice should have been given, this was given and liberty was sought for to withdraw the section 11 application to file afresh. And this has been filed. On the last occasion, my learned friend asked for the copies of these applications.
Yeah,
Has been
we've got
filed.
the soft copies, yes. But this happens when states,
Oh, I
state plus briefs sometimes get. But that
So are you opposing this?
I don't think there's much except that one claim is already dealt
yes,
with.
yes, that
So
is I am not.
the rest can be taken up now that the views are also very clear because this was set aside. Yes. The Supreme Court is also now very clear on that.
Review section 21.
Fresh section 21 notice is 261. The previous section 21 notice is also annexed.
All right, take down. The petitioner preferred the present application under section 11(6) of the Arbitration and Conciliation Act 1996, seeking appointment of an independent and partial arbitrator to adjudicate the dispute between the parties that survive between the parties arising out of the contract relating to the work of widening and strengthening of the existing intermediate lane carriage to a two-lane carriageway on the Bishnupur, Hotelpur, Arambagh Road, SH bracket में डाल देना SH2 in the district of Baghura यहाँ पे under CRF bracket में कर देना job number CRF WB 2009-2010-34. Full stop. The respondents floated a notice inviting tender being tender number 9 of 2011-12 for execution of the aforesaid work. Full stop. The bid submitted by the petitioner, a joint venture firm of government contractors, was accepted by the respondent, and a letter of acceptance was issued on 30th May 2011, followed by a formal work order dated 16/6/2011. Pursuant thereto, the parties entered into a contract incorporating the general conditions of contract. Full stop. The grievance of the petitioner is that although it commenced execution of the work and executed substantial portions thereof, the respondents failed to discharge their reciprocal contractual obligations. Full stop. Accordingly, the petitioner, according to the petitioner, the respondent failed to hand over a hindrance-free site stipulated under the agreement, which delayed the work. It is alleged that such defaults resulted in serious financial hardship to the petitioner and compelled it to incur additional expenditure during execution of the work. Full stop. Learned counsel for the petitioner submits that various communications were exchanged between the parties and a demand notice dated 27th September 2013 was also issued, claiming the outstanding due along with interest. Clause 25(3) of the agreement contains the arbitration clause. Yeah, page 262 में सारे detail. Contains the arbitration agreement. Full stop. The clause contemplates appointment of a sole arbitrator by mutual consent, and in the absence of consensus, constitution of a 3-member arbitral tribunal by nomination of one arbitrator by each party, with the presiding arbitrator to be appointed by the 2 nominated arbitrators, or in default by the Indian Road Congress. Full stop. Disputes having arisen between the parties, the petitioner invoked the arbitration agreement by issuing notice under section 21 dated 31st July 2015. Full stop. An arbitrator was thereafter appointed and award came to be published on 28 December 2018. Full stop. 28. Full stop. Under the said award, only claim number 2 was allowed, while rejecting the remaining claims. Full stop. The petitioner challenged the award under section 34 of the Arbitration Conciliation Act and before the competent court. Full stop. By judgment dated 29th April 2022, the commercial court at Asansol set aside the arbitral award in respect of all rejected claims on the ground that the award was unreasonable. Full stop. The award in respect of claim number 2, which had already been satisfied, was left undisturbed and attained finality. The petitioner thereafter approached. The said order was challenged by the respondent. The said order was unsuccessfully challenged by the respondent. Full stop.
Division means the appeal was dismissed for default twice, and thereafter never.
The said judgment dated 29th April 2022 was challenged by the respondent, which was dismissed for default, and no steps were taken by the respondent for restoration of the same. Full stop. The petitioner thereafter approached this court by filing an application under section 11 of the Act. Full stop. The said application was permitted to be withdrawn with liberty to institute a fresh application after issuing a fresh notice invoking arbitration under section 21. Full stop. Pursuant thereto, and by way of abundant caution, the petitioner issued a fresh notice dated 12th December 2025 under section 21 of the Act, which was duly served upon the respondents. Full stop. Despite receipt of the notice, no steps were taken by the respondent for constitution of the arbitral tribunal. Full stop. Learned counsel for the respondent states that the does not dispute the said agreement as well as the arbitration clause as contained in the agreement. Arbitration clause number 25.3, right, as contained in the agreement. Full stop. He consents to the appointment of the arbitrator in terms of the said agreement as well as the arbitration clause as contained in the.
Justice Somapti Chatterjee, we spoke. I spoke.
All right. Full stop. With the consent of the parties, Retired Judge Justice Shamapti Chatterjee is appointed as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter a reference in due compliance of Section 12 of the said Act. Full stop. The learned arbitrator shall be at liberty to fix his remuneration in terms of the fourth schedule or with the consent of the parties. Full stop. With the aforesaid direction, the present. All questions are to the.
Only one thing, the claim number 2 has been recorded. That has also been paid. If that can be put somewhere.
जहाँ वो लिखा है ना claim number 2 का तो उसमें डाल देना. The respondent states that the claim number 2 is already satisfied and satisfied in terms of the award.
Acha.
Highly.
Lordship, I am for the petitioner. In this, your Lordship, thrice, 4 times the service has been made. Your Lordship had asked to inquire other addresses. We have served on 3 addresses, the email ID. In one of the matters, I searched, there was an advocate appearing for the other party, respondent. I contacted that advocate as well, if he could accept notice and or give any details so that I could serve. But he refused. He said that he won't be able to take notice, and he didn't give any information as well. I was praying if paper publication directions could be.
How many
These are the affidavit of services. The first envelope had come as left endorsement is at page. The first page 4 of the affidavit of service is the email service. By post we served. Page 7 is the endorsement is left.
Where are you showing, Ms. Pandey? This one?
Your Lordship. There are 2 affidavit of services. First, the affidavit of service dated 15/6/2026.
Yes.
In that page 4 is the email service.
Yes.
Page 5 is served by post, 30th of April 2026 letter. The envelope, page 7, is the endorsement left at the back side, Your Lordship. It was served at CE 61, Sector 1, Salt Lake, Kolkata 64 on 4th of May 2026. Thereafter, we served on, they had entered into the agreement. Page 16 is the agreement, Your Lordship, in the Section 11 application. The address that was shown in the agreement is at FE 219. We served at that address as well. Page 11, the envelope came as no such person. Page 9 of the affidavit of service. Thereafter, we made another affidavit of service, which is the second affidavit of service. We served through post, which is at another address of 84 Salt Lake. That also came as no such person, no such addressee.
Affidavit of service dated 15/6/2026 as well as 29/7/2026 is taken on record. The first affidavit of service shows that the respondent has been served by email, though the postal receipt reflects that no such person stays on the address.
And left as well, Your Lordship. Left service is endorsed at page 7 of the envelope. And left is a good service. I can show judgments to that effect that
Shows that the person has left, and the other postal receipt shows that no such person stays on the address. The other affidavit of service dated 29/7/2026 shows similar remarks as no such person stays on the said address. Full stop. In such circumstances, learned counsel for the petitioner prays for a service by publication. Full stop. The same is allowed.
4 weeks time,
The
Abraham.
petitioner is directed to carry out the service by means of publication in a English daily, in a major English daily, as well as in a vernacular daily within a period of 4 weeks. The said affidavit of service shall be filed thereafter, just after 6 weeks.
Gratefully, Your Lordship.
I appear for the respondent.
At item number 15, Milord, I'm leading her. Am I audible? With item number 15, I appear for the respondent.
I'm led
There
by
was a
Mr.
direction
Rai.
to file opposition and reply. They have served us the reply. I am praying for 2 weeks time to file my reply.
Learned
Your
counsel for the
Lordship,
petitioner
kindly takes my opposition
is
on.
granted time to file his reply to the affidavit on operation filed by the respondent list after 4 weeks.
Deeply obliged, my lord.
Deeply obliged.
The reply after 2 weeks, list after. Opposition to.
From 16.
My lord, I am here on behalf of the petitioner, my lord. Pursuant to my lordship order passed earlier, the the application as well as order has been served upon the respondent. And on a PDB service has been filed, my lord.
Where is it? Last affidavit of service I've recorded that you'll serve them afresh. Where's the new affidavit of service?
This is filed in the department concern. The copy is lying with me. At page 9, my lord. The PDB service is found on 20th day of July, my lord. Page 9, my lord. The item delivered to the addressee on 17th July.
Page 9 is this mark. Sir, this page 9.
No, this is 20th July.
No such person in the address.
Yes, the corner has been two addresses, but one has been served, other has been returned to the addressee. This is the affidavit service model. Why can't you?
No such person, sir. Everywhere is the same. Just show it to him. The delivered which you are showing is the sender, not the person.
No, page 9, my lord.
Give it to him.
No, this is what. Yes, sir. 20th July. I forgot 20th July, ma'am. Page 9. No, wait,
Show me the other one. Who have you served? So, who's this?
To the one of the director of the company, my lord. At his native place.
Wait a minute, wait. You have not served the company.
He's the director. Yes, I served the company. Just you see my letter, this is 13th July 2026.
The first round of service which you had done it on the company.
At 6 page, my lord. Page 6 of the affidavit service.
Arey, sir, you have entered into the contract with whom? You have served upon one of the directors, not the company.
Yes, my lord.
Yeah, what about the company? You have made a party, the company has been made a party.
Company
We
had
don't-
made party.
We don't
But
even know if the director exists or not today.
So far the address given in the agreement, I have served, tried my level best, but returned back to addressee. Third time this is serving my letter with the.
Serve the company by publication if it is written.
Yes, my lord. Yes, sir.
Take down. Learned counsel for the petitioner states that despite all efforts, he has been unable to serve upon the respondents. He prays for substituted service by way of publication. Full stop. Higher point. This, under these circumstances, this court allows the petitioner to serve upon the respondents by way of substituted service in the form of publication in a way same English. 4 weeks, list after 6 weeks.
Recruitment.
I'm for the petition, madam.
Respondent number 1.
Respondent number 2 and 3 has been 2 and 4 has been ex parte, agreed ex parte, my lord. And the respondent number 3, we have effected service, and it is recorded to further effect further service, my lord. The envelope had returned with insufficient address. Thereafter, we have effected further service. This is the second affidavit of service. Not returned, my lord. My client has came to learn an alternative address of the respondent number 3, my lord. If my lord grants leave, we can serve on that address also. Thereafter, if it not service has not been effected, we can give a paper publication.
Learned counsel for the petition states that. But then you have to change the cost title with that.
That is without my lord's leave, I cannot change the title.
Learned counsel for the petition states that he has procured the fresh address of the respondent number 3. Full stop. He prays for necessary amendments in the cost title to serve upon the respondent on the freshly procured address. Full stop. The same is allowed. Necessary amendments shall be carried out. Within a period of 2 weeks. List after 4 weeks.
And here and now, I would
Amend the cost title, my lord.
You can carry out in the whatever here or
Different. Department party to which side?
No 18.
Lordship, in item 18, Mr. Jointo Sen Gupta is appearing for the respondent. He has to leave for some personal emergency, so he has personally requested me for your lordships to make it not today. Lordship, I'm not briefed in the matter, only on at his request I've come before your lordship. It was some personal emergency because of which he had to leave court.
Only one submission, my lord. This is a section 11 application. They are taking such time, and they've raised the frivolous ground of limitation in a section 11 case. So, my lord, maybe even if time is allowed, at least one day, not more than that, my lord.
not today.
Grateful, lordship.
No 19.
My section 11 applications, Lordship, 19 and 20, Lordship recollects that jurisdiction issue was raised, and I had proposed that only issue was with regard to the security deposit was deposited on a delay of 2 months. And at that stage, it was terminated. Lordship said, I asked my learned friend to use his good office, and Lordship says it can be resolved. He's not there today.
However, my lord, I have received instruction from the office that no one from the claimant party, they have approached the IRCTC.
I was also not understand that it was. I'll yes, I.
How will they carry out?
I understood. She spoke to me today. I'll do that. Keeps it a week hence, Lordship.
Make it simply not today then.
Yes.
Not today. Keep it after 2 weeks.
Yes.
2 weeks, well.
Keep it after 2 weeks.
19 and 20, Lordship.
19 and 20 both.
Yes, your lordship. Similar. 20. Unish Kudi.
After 2 weeks. Keep it after.
Great.
Not 21.
For the respondent number 1, Mr. Ritendra Banerjee is appearing in this matter.
For the petitioner, my lord.
My lord, he's on the.
My lord, I'm praying for not today because the advocate on record, Mr. Shobik Mitra, his mother is ill. So I'm on, like, in his personal God, I'm only praying for not today.
Not today.
In this matter, I'm happy. Oh, very good. The next week, lordship.
Next week.
After
Next
5th.
week.
After 5th, yes.
Next week. Next week. Yes.
Lordship, this is my section 11 application. It has been delivered on the respondents. Lordship, may I hand up the affidavit of service? Your Lordship, the postal receipts are at page 7 and page 8 onwards are the track reports. It shows that item delivered addressee. May I
Respondents are 1 or 2? 2.
Yes, respondents 1 and 2. 2 and 3, Your Lordship. Your Lordship, respondent number 1 has 2 addresses. It has been delivered on both, and thereafter it has also been delivered on respondent number 2 and 3 as well.
All three are served.
All three are served. Yes. May I place my case, Your Lordship? Your Lordship, a term loan facility was granted for rupees 1 crore 20 lakhs. The sanction, while we did a sanction letter dated 17th October 2023. The sanction letter is at page 17 of my petition. Kindly comes to page 17, Your Lordship. Your Lordship, it was a term it was a term loan facility for 1 crore 20 lakhs and for a tenure of 36 months. Thereafter, at page 20 and 21, Your Lordship will find the signature of the respondents. Your Lordship, the agreement for the term loan facility dated 27th October 2023 starts at page 22, Your Lordship. Just the next page.
Page 20.
Starts at page 22 of my petition. The term loan cum guarantee agreement for term loan. It has been executed on the 27th of October 2023. Your Lordship, there's also a guarantee clause in this, clause number 8, which is at page 25. And the arbitration and the jurisdiction clause is at page 27 of my petition, Your Lordship. Your Lordship, if you kindly come to page 30 of my petition, the place of execution is also mentioned as Kolkata. And at page 35 of my petition, which forms a part of the Schedule 1, in serial number 18 and 19, the place of arbitration and the jurisdiction is mentioned as Kolkata as well.
Sole arbitrator or what is it? Party advocate?
Yes, Your Lordship. Sole arbitrator. May I place the arbitration clause, Your Lordship?
That's what I was saying.
Page 27.
Yes, this is page 27, and then what are you showing page?
Page 27, and thereafter page 30, Your Lordship, where the place of execution is mentioned as Kolkata. And if you kindly come to page 35, Your Lordships, in serial number 18 and 19 of the Schedule 1, the place of arbitration and the jurisdiction is mentioned as Kolkata as well.
The notice?
Your Lordship, the loan recall notice is dated 17th of March 2026. It is at page 53 of my petition.
Then 21?
21 is at page 76 of my petition, dated 6th of April 2026, Your Lordship. The total outstanding amount is rupees 55 lakhs 98 crores, 98,366.41. Your Lordship, at page 84 of the section 21 notice, I had also indicated 3 names for appointment, but they had not replied to the same. And this has been delivered also. The track reports are at page 86.
Take down. Affidavit of service declined record. Despite service, none appears for the respondent. The petition has preferred the present application under section 11(6) of the Arbitration Conciliation Act, seeking appointment of a learned sole arbitrator to adjudicate the dispute and differences which have arisen between the parties in connection with an agreement for term loan dated 27th October 2023, read with registered master terms and condition for term loan dated 31st December 2018. These are the only 2 documents, right?
Yes, Your Lordship. The sanction letter and the agreement for term loan. Sanction letter is at page 17 and the agreement is at page 22 of my petition.
Learned counsel for the petitioner submits that the petitioner had advanced a term loan for working capital requirements to the respondent. Full stop. Respond number one. To respond number one, the petitioner sanctioned a credit facility of rupees 1 crore 20 lakhs and the parties executed an agreement for term loan dated 27th October 2023. October 27/10/2020. Full stop. Read नहीं इसको उसको करते हैं ना read with the registered master terms and condition of term loan dated 31st December 2018. Full stop. Respond number 2 and 3 executed personal guarantee securing the due repayment of the loan and undertook liability coextensive with that of respond number 1. Full stop. The respond number 2 and 3 executed personal guarantees securing due repayment of the loan. Learned counsel further submits that the said loan was duly disbursed, which was received by the respond number 1. Full stop. However, after making certain repayments, the respond number 1 persisted in defaulting in servicing the loan account. Full stop. Despite repeated requests and reminders, the outstanding dues were not regularized. Full stop. Consequently, the loan account was classified as a non-performing asset on 11th October 2025. Full stop. Learned counsel for the petitioner further submits that the said loan was recalled by issuing a notice dated 17th March 2026, and further the petitioner had issued a notice under section 21 for invoking the arbitration clause as contained in the said agreement. Arbitration clause number 13 as contained in the said agreement. Full stop. Despite service of the notice, none of the respondents took any steps for constitution of the arbitral tribunal. Full stop. Learned counsel for the petitioner submits that according to that the arbitration clause contains the arbitration clause indicates this court having the jurisdiction and the seat and venue of the arbitration is within the jurisdiction of this court. Full stop. This court has considered the materials placed on record and the arguments advanced by the learned counsel for the petitioner. Full stop. The existence of a valid arbitration agreement between the parties is evident from the agreement for term loan read with the registered master terms and conditions. Full stop. The dispute raised by the petitioner arise directly out of the said loan transaction and are covered by the arbitration agreement. Full stop. The petitioner has duly invoked the arbitration clause by issuing a notice under section 21 of the Act, and the respondents have failed to act in accordance with the agreed procedure for appointment of an arbitrator. Full stop. The scope of examination under section 11 of the Act is confined to the existence of a valid agreement containing a valid arbitration clause. Full stop. Upon consideration of the materials placed on record, this court is satisfied that a valid arbitration agreement exists between the parties and the same between the parties, and that live disputes have arisen thereunder, requiring adjudication through arbitration. Full stop. No, under such circumstances, this court is satisfied that the requirement for exercise of jurisdiction under section 11(6) of the Act stands fulfilled. Accordingly, this court appoints so and so. How much is 120? 55 lakhs.
55 lakhs, Your Lordship. Any junior member of the mid-level council may be appointed.
If anybody is there, we'll appoint somebody. Or will any suggestion? Junior member. How many years you have put in? How many years you have put in? 16. We'll appoint you. Miss so and so, give your. Miss so and so is appointed as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter reference in due compliance with Section 12 of the said Act. Full stop. The
Notice. Your Lordship, may I hand up the notice of motion?
notice of motion.
Your Lordship, this is my application.
Last evening I received the brief, my lord, from ministry.
Why only last evening you received?
But kindly give me 2 weeks time so that I can take instruction and come before Lordship, my lord.
2 weeks, Your Lordship, they have already given their stance in their reply. I'm already covered by a judgment, Your Lordship. I will just
One
indicate.
hour, my lord, defense has to come there. I have just
No,
disciplined.
I'm not going to give you time. Why should I give you time, sir?
My lord, kindly make it in the next week or next Thursday. Otherwise,
Your Lordship,
let me
I'm
have
objecting.
Next Wednesday, not Thursday. Next
Wednesday.
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 Next Wednesday.
I'm grateful, my lord.
Not today. Next Wednesday. I'll just record that learned counsel for the respondent states that he has just received the brief in the evening. Prays for an adjournment to get himself prepared. List next week.
My lord, in item number 24, my lord, I beg to appear on behalf of the petitioner. This is my application under section 11. Now, my lord, this was a contract for supply, installation, commissioning and maintenance of naturally ventilated polyhouse. The respondent, after issuing a show cause notice, my lord, they have terminated my contract.
Yes.
It was, I should be candid, my lord, it was a back-to-back contract. The parent employer was government of Uttarakhand. They terminated their contract, and thereafter, with diverse allegations, the respondent has terminated my contract. Now, my lord, in the meantime, my lord, I have replied to the show cause notice that was not considered. Then, my lord, I issued a notice under section 21 for commencement of arbitration proceeding in terms of the arbitration agreement contained in the purchase order. My lord, the purchase order starts at page 33 and relevant arbitration clause is there at page 36, my lord. Fourth bullet. My lord, may I read for your lordship? All questions, disputes, and differences whatsoever shall arise between the BCL, that is the respondent, or BCL's customer and you, upon in relation to or in connection with the contract, may forthwith be given to the notice in writing or the existence of such question, disputes, differences, and
disputing it.
Lordship.
Yes. On what ground?
Lordship, the 21 notice is defective, Your Lordship. Lordship kindly takes the 21 notice, which starts at page 53, annexure J. Lordship will thereafter kindly straight away come to Lordship page 60 minute. Para 14 at the bottom. Para 14, may I read, Your Lordship?
Yes.
Therefore, in terms of the arbitration clause mentioned in the said purchase order, which is a duly signed and accepted and acknowledged agreement between the parties to the said purchase order dated 19 July 2024, the dispute now has to be settled as per said arbitration clause of the said purchase order or agreement, and hence the same shall be settled as per the Arbitration and Conciliation Act
with the venue or seat of arbitration proceeding to be held at Dehradun, as per the address mentioned in the said purchase order dated firstly, my lord. The invocation notice says that the jurisdiction will be Dehradun, which is the Nainital High Court, your lordship. Secondly, my lord, no dispute and claim is specified in the said invocation notice. Lordship, that is, my lord, bad. The 21 notice has to specify the claim and the dispute. May I rely on, my lord, two judgments of the Supreme Court, my lord?
No, but Mr. Mukherjee,
Yes, my lord.
what is this? Dehradun, Calcutta.
My lord, I tell your lordship, if your lordship kindly be pleased to go back to page 36 once.
I don't need
It
to.
has to be
Your 21 is defective.
My lord, it was a wrong choice of word, but it has to be in any event, my lord, it has to be before your lordship. It has to be before your lordship.
This petition under section
And
11.
there was no reply.
See, how
There
could
was
you
no.
that venue and seat of arbitration to be held at Dehradun as per the address mentioned in the said purchase order?
My
To
lord,
be the address of
my lord, kindly ignore that sentence. My lord, kindly come back to
I can't
page
ignore that
36 once.
sentence, Mr. Mukherjee. I can't ignore that sentence. How can I ignore that sentence?
My lord,
This is your
subject to
21
correction by
notice. I can't ignore anything. This is your notice.
My lord, subject to correction by your lordship. My lord, in any event, I just have to invoke section 21 for commencing of the arbitration proceeding.
Invoke section 21 with the correct facts, not invoke section
With the
21 with
correct,
wrong.
my lord, my lord, only
Mr. Mukherjee, you want me to dismiss
that
it on this ground? I can do it. You take it in appeal, and you can have an intellectual debate before the division bench.
My lord, may I come back to your lordship, my lord?
Come back with your instruction.
Lordship, I have one more limb, my lord. No specific dispute and my lord, claim is
See that
specified.
first. Let him overcome this.
Lordship, the affidavit of service is already given.
Nothing today. Not today. Give it back.
My lord.
Great.
Yes, Mr. Karma.
So 25 and 26, my lord, both are similar matters and application under section 11 for appointment. But the only difficulty is, my lord, the service could not be effected, although, my lord, section 21 notice was refused from that address.
But you have to, service has to be effected.
My lord, the only difficulty is, my lord, if I send again, my lord, then the same thing will happen, that no such person in this address. Although, my lord, it has been refused from that address, section 21, I have annexed that. It's the petition.
21 refusal is good enough. You get the word refused. There's no problem.
The difficulty here, my lord, it is coming as, my lord, this petition.
You have to
Lord,
manage.
in that case, Lord, I think, Lord, reserving, Lord, will near to the same place. Lord, so if a paper publication, Lord, can be of some help.
At least try the resurveys.
Very well, Lord, as your lordship please.
Learned counsel for the
Lord, may I file the affidavit of service at that time?
affidavit of service taken on
To matter, yes.
service report indicates that the respondents have not been served. Learned counsel for the petitioner seeks and is granted 2 weeks time to effect service upon the respondents and file a fresh affidavit of service. Just after 3 weeks.
So the next
post
matter.
office, they'll do the same thing. Talk to the post office, they'll do it.
Great. The next is also the same, 25 and 20.
Same order. Affidavit service have you filed?
Yes, Lord, both affidavit service. Great.
27. I'll
No,
come
no,
back.
this is my section 11.
Come back.
This is my section 11 application. The dispute regarding the partnership deed. And the page 26 is the arbitration clause. And page 96 is the section 21 notice.
So what was this contract?
Is a partnership.
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 Yeah, filed arbitration for dissolution of partnership.
You're opposing the. Are you opposing the appointment of the operator?
Kindly appoint. Only one thing, my lord. We have already initiated a criminal proceeding against the petitioner. Let that be continued. Pendency of this.
Why should we make any observation on the criminal?
Because they are saying before the police authorities that
Separate
that's
chapter,
the difficulty. That's we are suffering.
But that's a separate proceeding. Why should we comment about?
But since they are tracing before the authorities that this is a civil dispute, proceeding is pending before the High Court for appointment of arbitrator, police is also not taking appropriate steps. That's the only issue. Rather,
In my section 11, I'm not going to make any comment regarding your criminal, cases which are pending or anything of that sort. These are separate proceedings.
But we appointed. We have no issues on that, my lord. Sole arbitrator may be appointed.
Where's your 21?
Section 21, page 96.
All details are there?
Yes, yes.
Take down. The petitioner has preferred the present petition under section 11(6) of the Arbitration Conciliation and seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the partnership deed dated 5/11/2020 executed between the parties. Full stop. Learned counsel for the petitioner states that on 5/11/2020 a partnership agreement was entered into between the petitioner and the respondent number 1 and 2 for carrying out the business of Arogya Nursing Home. Full stop. In terms of the said partnership agreement, the profit and losses ये कर देना in क्या लिखा है in terms of the profit and losses of the partnership business were agreed to be shared among the parties in the ratio of 40-20-40. First partner 40%, second partner 40%, and the third partner 20%, respectively. According to the petitioner, the said nursing home was initially operated by respondent number 1 as a proprietorship concern. Full stop. Subsequently, respondent number 1 requested the petitioner and the respondent number 2 to join the venture and convert the proprietorship concern into a partnership business. Full stop. Pursuant thereto, the partnership agreement was executed between the parties, and all the partners contributed capital and labor towards the operation and expansion of the nursing home and its ancillary business activities. Full stop. The petition contends that during the course of the internal audit conducted in or about September 2025, serious financial irregularities came to light. Full stop. It is alleged that respondent number 1 siphoned off substantial amount from the account of the partnership business and had utilized the funds belonging to the partnership business for personal purpose without the knowledge and consent of the other partners. Full stop. The petitioner further alleges that the respondent number 1 misused banking facilities and operated accounts in a manner prejudicial to the interest of the partnership firm. Full stop. Upon becoming aware of the alleged irregularities, the petitioner had called upon the respondent number 1 to furnish proper accounts of the partnership business. Full stop. Since no satisfactory explanation was forthcoming, the petitioner lodged criminal complaint against the respondent number 1.
Another criminal complaint also be lodged by the petitioner against the respondent number 1.
That's what I'm saying. Petitioner number 1 against respondent number 1. Full stop.
But we have also responded. Add to that, we have lodged criminal.
Full stop. The record disclosed that the petitioner thereafter issued a notice dated 27/1/2026 calling upon the respondent number 1 to render account and explain the alleged financial transactions, financial irregularities. Full stop. The respondent number 1 replied to the said notice dated 2/2/2026 denying all the allegations. The petitioner further issued a notice under section 21 of the said act invoking the arbitration clause as contained in the partnership agreement. Notice dated 16/3/2026 as contained in the partnership agreement. Full stop. The petitioner claims entitlement to various monetary and other reliefs out of the alleged misappropriation and breach of fiduciary obligation, including compensation, damages, dues, remuneration, and settlement of partnership accounts. Full stop. The petitioner quantified his claim to rupees 1,544,154,9381. Both the parties submit that the partnership deed contains an arbitration clause, being clause number 19 thereof. The said clause provides that disputes and differences between the parties shall be referred to arbitration and that the arbitral tribunal shall consist of one nominee of each side and a third person to be nominated by the two nominee arbitrators. Full stop. Pursuant thereto, the petitioner had nominated. You want 3 arbitrators?
No, sole arbitrator, my lord.
All right. Person nominated Buddhadev Ghosh, advocate, as his nominee arbitrator. The respondent, by his letter dated 8/4/2026, nominated Nilanjan Bhattacharya as his nominee arbitrator. Full stop. It is the case of the petitioner that despite such nominations, the two nominee arbitrators failed to appoint the third arbitrator/umpire as contemplated in the arbitration clause. Full stop. Consequently, the proceedings could not be initiated. Full stop. Both the parties at this stage, both the parties consent to the nomination of a sole arbitrator to adjudicate the dispute between the parties. The parties submit that an arbitrator shall be appointed in terms of the arbitration clause as contained in the partnership deed. Full stop. The parties state that instead of 3 arbitrators, a sole arbitrator can be appointed by this court to adjudicate the dispute between the parties. Full stop. With the consent of the parties. Give a name.
আমিও পেয়েছি, আমাকে বলেছে অরিজিতা ঘোষ বাজাবরি। এও 15 বছর প্র্যাকটিস করছে। জজকেই বলে দিই। Kindly appoint my lord from your lordships. Anybody?
How much is the amount? 4
crores.
Who do you want? A senior advocate?
Certainly, my lord, senior, my lord.
It's the schedule fees, my lord. So whether yes.
Who do you want? What is your suggestion?
Orita Ghosh.
My suggested, my lord, Sucharita Rai, Bharat room number 14.
Orita Ghosh.
But both of you don't agree on that name. All right. Any other name? What about?
May I suggest Miss Pandey to
Miss not Amrita, Namika. What's her? Anamika. It's Anamika Pandey is appointed as the learned sole arbitrator to adjudicate the dispute with the consent of the parties. Miss Anamika Pandey is appointed as the learned sole arbitrator to adjudicate the dispute between the parties. She shall enter her reference in compliance with section 12 of the said act. She will be entitled to fix her remuneration in terms of the fourth schedule of the act. All points related to maintainability, arbitrability, limitation shall remain open to be adjudicated by the learned sole arbitrator. A copy of this order shall be communicated to the learned arbitrator to take effective steps. With the aforesaid direction, the present petition stands dismissed.
Get pulled.
Mr. Banerjee is for the petitioner, I am for the respondent.
Very good.
Mr. Banerjee is in a different time zone. As my lord, he's not here, my lord, as the word is.
He's not here?
Sons, my lord, graduated from King's.
Oh, okay.
He's gone for the convocation. This I learned, my lord, I was in Chandigarh on Monday. So I wanted to speak to a learned judge, my lord. He didn't have work before her. But
Then
I
we'll
was
have it.
told,
We'll have it next week.
yes, my lord, on Wednesday. But my lord, for precedence, my lord, no commercial urgency will work. But it is so very interesting. I want 1 minute, my lord. So this is our note. Section 11 filed by my learned friends in Delhi, by us in Calcutta. Delhi court said,
We have
the other way around, my mistake. So the Delhi court said this is prior in time, so this has to be heard first. So my petition there is getting adjourned. Now this is a conflict between forum selection clause and, my lord, the seat clause. If your lordship takes the note once, my lord, kindly see, my lord, the first page of the note.
Yes. Clause 22.
Yeah. Thank you.
So, my lord, please see the clause. Clause 1 says, 22.1, sublease deed shall be governed by and construed in accordance with the laws of India. The parties irrevocably agree that subject to 22.2 and 3, courts at Kolkata will have jurisdiction. Then 22.2 and 3 is seat, Delhi. But one says subject to 22.23, which really puts 22.2 and 3 above 1. And then 4 also says Kolkata. So, my lord, I've analyzed the clause and I've made a small chart at page 3, paragraph 5B. So, it's, my lord, New Delhi seat 22.2, New Delhi seat 22.3, which is placed above 22.1 because it's of that part, my lord, subject to 2 and 3. And then 4, my lord.
You have filed it in Delhi.
Yes.
keeping the seat clause as primary,
Yes,
not the forum selection.
not the forum selection. So I say, my lord, that because of the way the clause is arranged, seat anyway by parties has been given primacy, because one says subject to 2 and 3.
Is it?
Decided issue. But we've also, my lord, relied on all possible judgments.
What is the law?
Law, my lord, is seat prevails.
Seat.
Seat.
Which is the latest judgment? Grand Motors. Which
My lord, we've given the judgments, my lord.
Which is the latest one on this?
Latest one, my lord, two classes, my lord. One is number 5 at page 4 of the note. Arif Azim is the latest by Supreme Court. Calcutta High Court view, my lord.
Arif Azim, we have also relied in.
Yes, in that other salty. Then, my lord, then there's one more, which is JK Economics. My lord, please come to page 9 of JK Economics. My lord, subparagraph 2 is once seat is designated, courts of that place alone shall have exclusive jurisdiction. The designation of seat operates akin to an exclusive jurisdiction clause. So, my lord, this is the last. Our court, my lord, has also another learned single judge, my lord, has been pleased to decide this issue, that it will have primacy. That matter went by SLP, my lord. SLP, my lord, question of law left open. Height insurance. Then there is Justice Bosch.
What was the decision by the learned single judge?
That seat will have primacy. Justice Boschak, my lord, 4 years ago, before the seat doctrine actually developed, said that no, forum selection clause would have primacy. But
I'm not expressing my mind, but that is also something which can ring the bell.
Yes. It's kindly decide next Wednesday, my lord. It's interesting. We'll come and do it. Mr. Banerjee is also here. I have found out through my learned friend. He's available, my lord, 5th. Very interesting point.
Did you go through that Harsha construction?
Yes.
That was also interesting.
That was interesting.
See what Mr. Banerjee asked.
Yes. Not some precedents. Having regard to the nice question involved. Nothing else.
Why precedent? Matter that it's been taken out.
Very good. Yes, it is.
Last time also it was taken out.
Yes, it was. We have taken accommodations many occasions.
That's correct. This one special. Wednesday.
Grateful.
Shall I just record at the proxy council so and so? I'll just record that. What's your name? Give your name.
Aditya Farkar. I've
Proxy council so and so states that the main arguing counsel, Mr. Ratnanku Banerjee, is not available. He prays for an adjournment. Let this matter be adjourned to Wednesday. 5th.
Great. Very grateful. Thank you.
Appear for the respondent. Your Lordship, there's still talks of settlement going on. If it could appear on coming Friday, the first.
Next week?
Your Lordship.
Order should दिखाना है. Learned counsel for the parties state that settlement talks are underway. They pray for an adjournment. Let this matter be adjourned for 2 weeks. Let it be 2 weeks so that
2 weeks.
something comes out of it.
Meantime, the respondent to make payment.
2 weeks. I'll give 2 weeks. There is
Much obliged.
just a minute. Just a minute. Well, it failed before the mediation.
Your Lordship, because his father had passed away, and during that period, the time he could not make the remaining payment. He paid 6.5 lakh rupees. In this week, he'll pay another 13 lakhs. So approximately 3 lakhs. Sorry, 3 lakhs. Approximately 20 lakhs plus amount would be remaining.
What do you say?
We have spoken if settlement monthly.
We have the same instructions. The respondent's father expired. So
Much obliged.
After 2 weeks.
What? I'm appealing for the petition, my lord. There are two related Section 9 applications, my lord. As far as I remember, my lord, on the last occasion, my lord, it fell before from your lordship, my lord, whether all disputes can be referred to arbitration. My lord, my instructions, we have no objection as regards, because my Section 21 is already there. If they have a counterclaim, they will raise it before the arbitrator, my lord. And if that counterclaim is not admissible according to us, we will take appropriate steps there.
But my lord, we have responded subject. If my learned senior friend has concluded, we've
No,
as to
not
this,
on the merits.
No, on this only that much, sir. My lord, the petitioners who are the lenders in respect of a finance agreement had sent us a Section 21 notice in December and thereafter March of 2026. We responded by way of a composite reply to the entire matter. My lord, only one thing, we indicated that we have disputes qua the petitioner herein, who is the lender, as well as the holding company, because the petitioner is the wholly owned subsidiary of a holding company, which is Shrey Infrastructure Finance Limited. My lord, we have certain disputes with them as well, and we've stated on oath, or rather in our reply, my lord, that since the transaction was in effect composite, insofar as the holding company and the subsidiary, we want the entire dispute, entire gamut to be referred to arbitration. If my learned friend is agreeing to that, we have no dispute at all.
No, I am agreeing to my Section 21. I am saying, my lord, if my dispute goes, you are the respondent.
You can raise whatever
you are free to raise your claim there. And then I will decide whether that claim will fall within the arbitration agreement. I can take my steps accordingly.
No, since it
At
is
this stage, how can he give consent to the fact that, what should be the scope of arbitration? Or what should be the scope of your counterclaim?
Not
my 21 can be referred.
My submission is, my lord, if my lord will kindly have a look at the 21 notice of, I am not on the contours of my counterclaim. My lord will not take me amiss. I am not asking for this court to adjudicate upon what counterclaims I will raise. Only as to the parties. Only as to the parties, because that will be
The
relevant.
parties also, that has to be taken care of by the arbitrator. He will see whether the arbitrability is there or not.
Of course.
That issue also he has to decide.
Of course. My lord, if my lord grants us that liberty to pray for this, because or else, my lord, if today the order is there,
See, if I grant that liberty, it is
taking
literally
note of my Section 21 notice.
it is literally allowing that.
Well, of the liberty only to be decided in
If
accordance.
the moment I grant liberty, I have any observation on that. I'm literally allowing. I'm literally getting into the arena of the arbitrator.
I appreciate.
I don't want to do that.
Well, in that event, we'll, my lord, just pass it over. I'm not asking for an agent. We'll kindly pass it over. Let me just have a word with my clients, my lord, and we'll mix it. If my lord will kindly pass it over for some time. Pass it over. 15 minutes. I'll just make a phone call.
I'll have it after lunch or what? You'll come back now?
Sir, in 15 minutes. You can
At
come
the
back
time
with
of-
one-
All right, pass.
1
Yes.
p.m. 1 p.m. will come. 1 p.m.
Both the matter, 28, 29. Oh, sorry. This is 31.
31, 32.
31.
And around 33.
My lord, this is that matter, my lord, where my lord had deprecated the respondent's conduct, and my lord, despite that repeatedly. No.
Kindly fix it, my lord. 2 p.m. Senior will be there surely, my lord.
Pass over. Let them come. There's no point giving another.
Yes,
day.
sir.
What is happening?
Nothing. I've got a supplementary affidavit, the completely wrong statement. Again, I don't know how they have so the audacity, my lord. After your lordship has passed an order, again they're making a wrong statement. I mean, either there is complete misunderstanding at their end. I'll the supplementary affidavit.
Let
Okay,
pass.
2 o'clock. 2 o'clock. 2 o'clock. My lord has kept it at 2 o'clock. 34.
34, Your Lordship, I am on behalf of the petitioner. On the last occasion, an injunction application and receiver was appointed. Your Lordship, we have also served the Section 21 notice in the meantime, if I can serve a copy. Submit. Your Lordship, so far as I am aware about this, Your Lordship, the asset could not have been able to be traced.
No, asset is there,
Oh.
but without police help, it cannot be brought along. Asset is there. Lying on.
अच्छा, 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 भीतर है, भीतर है।
Yes, yes.
The local police had given a direction.
Yes, the direction is there.
But they have not arranged.
Sir, so far as my instructions are concerned, Your Lordship, the local police station could be like the receiver was supposed to serve a notice upon the local police station. In any case, Your Lordship, we are ready, if need be, we are ready to comply and we are arrange for a local police station. We can send a notice to them. But normally, Your Lordship, the learned receiver.
You are supposed to,
No, directly. We are directly.
madam, you are supposed to take care of this.
Yes, my lord. Next day, I will go.
Actually, for the first.
They have not.
They have
They
not.
have not communicated with the police. But
You are supposed to communicate with the police,
yes,
madam, not them.
But I want to go there. But
Your Lordship, we
next week, my lord. I positively go.
will assist in the process in the meantime, Your Lordship.
Give me a 1 week, my lord.
Your understanding of the order is incorrect. You are supposed to get the police assistance
Yes,
to carry out the order,
Yes, my lord.
not them.
Yes, my lord. I want to go, but they had not.
I don't have that instruction. I'm
Yes.
just the company document.
No, तो मेरे को
ठीक,
बोले
ठीक,
चिना
ठीक,
मेरे को करेंगे.
Fair enough. So far as we are aware that the assets are there, but possession could not be taken.
Yes, my lord. That's what I
Thank you.
want.
Thank you.
Yeah.
Thank you. Thank you. Thank you. Thank you. What's that?
You should have written to the local police station.
Yes, my lord. Next day I will. Give me a 1 week time, my lord.
You file your report on the next date. Conclusive report. Give it back to it. At the request of the petitioner, let this matter be adjourned to for 2 weeks.
Grateful, Your Lordship.
Yes, my lord. 35, my lord. This is my report, my lord.
Similar situation, Your Lordship, against the petitioner is the same, different respondent, Your Lordship. So Section 21 notice we have sent in the meantime. So far as we are aware, the asset could be located, but they have, I believe, the asset IDs and everything has been scratched off or deleted. Pictures
Taking a
I do not have.
photograph, my lord.
I do not.
Taking a photograph.
You take possession of it.
Yes,
With the police assistance.
that is the.
I asked the petitioner lordship to call police.
You have to.
But
Lordship, in this case, the
but-
asset is there.
petitioner says not necessary. That's why I not call, my lord. That's
Lordship,
why.
the asset was, we are not on anything. We can I don't have any instruction on that part, your lordship. So far the police protection or help is concerned.
Order is there.
Yes, your lordship. I am not contesting that, your lordship.
Yes.
The learned receiver has gone there. The asset is there. That can be, but the asset ID, those has been scratched off. So that there is a dispute. So far as I am aware, the asset ID cannot be read, your lordship.
They deleted the
And at that point of time, it was informed that because it cannot be read, the possession cannot be taken because it cannot be identified whether it is the same asset or not.
necessary, not they told me not necessary. That's why I
Or take down report filed by the receiver is taken on record. The report indicates that the indicate that the hypotheticated machinery that on the hypotheticated machinery the asset ID number has been deleted. For this reason, the receiver could not take possession of the said
21
machine.
notice. 21 notice.
Learned counsel for the petitioner states that he has already issued notice under section 21.
Yes, 21 notice, your
So
lordship.
why do you want to pursue this? It's over then. The section 9.
No,
In the
we-
section 11, get the
We have just sent it. It is still not there. In the meantime, there is an order as well, your lordship, or not
this
selling.
will be listed after 2 weeks.
Lordship, kindly direct me if you position the machinery. Then
You will only take the possession if the number is there. You can't take it. They have to verify that. Only if they verify, you can take it.
Which is the 21 notice that we have served in the meantime.
I've recorded that. I don't need to keep it on.
Okay. Your lordship, in both the cases, the remuneration has been paid. It will, lordship.
If you want her to go and take the possession, you have to establish that it is the same equipment. How will you establish? It's up to you.
Your lordship, we'll try. If we can, then we'll inform her once again, lordship.
I already located Lordship machine. Photographs. I served you copy, Lordship.
Give a copy of the report.
The Lordship appearing on behalf of the
Lordship,
respondent.
this-
On earlier occasion, there was a specific direction upon the petitioner to put in
Lordship.
affidavit regarding the
So
jurisdiction.
that
Yes,
they-
Lordship, Lordship, my clients have agreed to withdraw the section 9 petition.
good for them.
Last day's hearing had some effect.
Learned counsel for the
Your Lordship,
petitioner.
there must be a cost, Your Lordship, because Your
Lordship.
Lordship kindly consider client came all the way from Delhi to affirm the affidavit at least.
All right.
Lordship, they are defaulters after all.
No cost on defaulters. Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
Lordship.
The present petition stands dismissed with liberty. Liberty paid for is granted.
Objection. Lordship, I wish to withdraw the application.
Learned counsel for the petitioner seeks to withdraw the same order. Sir.
Same order, Lordship.
Same order.
On instructions, I am also paying for some costs. In fact, Your Lordship, I had given Your Lordship some armament with respect to the judgment of Harji, but I will leave it to Your Lordship.
Cost, you also make mistakes.
Of course. Your Lordship, not on
Cost
that.
is only when
On instruction, I am saying this because Lordship, this is the 5th occasion. It is only after Your Lordship's rightful reprimand on the last day that
you're
they've come
getting
down.
5 opportunities to appear.
Your
And
Lordship,
make
then
your submission.
given
Same
the brief,
hearings.
I may submit that in fact we are lucky that this is not in the form of a judgment because there are times that we are appearing on that side.
Yes.
So I'm so grateful to you.
Your Lordship, this is my section 9. On the 12th of June 2026, an order of injunction was granted. The interim order was granted for a period of 8 weeks, Your Lordship. We have served the order on the respondents. We have also issued our section 21 notice on the 25th of June 2026, and we'll file a section 11 application by today, Your Lordship. I'm just humbly beseeching if the interim order, it's expiring on the 6th of August 2026. If it can be extended for a period of 2 weeks till that time, the section 11 application will be, Your Lordship.
When did you file your section 11?
Today, I'll file it today, Your Lordship, by today.
Not filed it?
I'll file it by today, Your Lordship. I have issued my section 21 notice on the
When did you
25th.
issue 21?
May I hand up the 21 notice?
When did you issue it?
25th of June 2026. Your Lordship.
Take down. The interim order granted earlier by order dated 12 June 2026. Extended further for a period of 4 weeks. Further for a period of 4 weeks. List after 5 weeks. In the meantime, file it so that we can dispose of both the petitions.
Yes. May I hand up my affidavit of service, Your Lordship, which I have?
Affidavit of service taken on record. Service report, despite service, none appears for the respondents. They have been served.
Yes, they have been served. It has been delivered. Grateful.
Lordship, item number 39 and 40, receiver was appointed to take possession. But Lordship, we have not been able to trace the asset and we don't want to keep this pending. Lordship, whenever we will be able to trace the asset, we can proceed before the arbitrator.
Learned counsel, you want to withdraw this?
Lordship.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn, with liberty to file appropriate proceedings in accordance with law. Both 39, 40.
Both 39 and 40. Yeah.
Forty-one. 41 and 42 are connected.
41.
41 and 42 are connected. No, this is the matter that I had mentioned. Lordship was pleased to keep it today. But I'll just give you a brief overview. Ashitya, which is the respondent, entered into a lease agreement with a company called Log9.
Company called?
Log9. Respondent enters into that agreement with Log9. What is the arrangement? The respondent leases out certain EVs, electric vehicles, to Log9. Log9 is to pay lease rentals. And in this, the guarantor is the other respondent in item number 42. The name is Equaro. EQUAR.
That's the name of the guarantor.
That's the name of the guarantor. Thereafter, I enter into a factoring agreement with the respondent, where the respondent assigns all the receivables from Log9 to me, with a specific clause called a recourse clause, that if Log9 does not pay or fails to pay these lease rentals to me, then Ashitya, the respondent here, will make good that clause. I'll show that clause. Log9 accepts this because we write a letter saying this factoring agreement has happened, and the Log9 starts paying the lease rentals to me. Log9 thereafter unilaterally terminates the agreement for whatever reason. Before that, Log9 fails to make payment in excess of approximately 4 crores of lease rentals to me. I write to Ashitya, the respondent, that under this agreement, this is what is payable by you to me, because there's an arbitration clause, and we also invoke it by way of a section 21 notice. All that I seek from your lordship today is, if they agree, then we can have an arbitrator appointed here and now, and we take it up there. The entire financial worth of this this company, this respondent is only 36 lakhs. My claim exceeds 4 crores. So this amount be secured and we can go into arbitration.
Can't be.
To the extent that they can, to some bank account, I'll just show the clauses. Under the agreement, they have that obligation.
That might be, but then it can't be in a section
9. They'll
usually treated as 11 today.
No, 9 I'm not going to pay. Then I'll file my 11 separately. But if they had agreed to this, then I'll file the 11 separately because I thought that would have.
Opposition because things are not as they say they are.
Very well.
In February 2020,
I'll just show a few clauses, my lord. May I just indicate?
Disputed, my lord. I am not disputing there is a recourse clause. I am not disputing. All I am saying today is February 2025, they say the first default is committed. I have emails galore from January 2025 when I'm constantly calling upon them, saying them, please take possession of the secured assets. These assets were hypothecated in their favor. There were joint meetings. Log 9 offered to surrender possession. They did not take the securities.
No, Lord, I'll deal with that. I'll show that email. I'll deal with it.
No, not
Lord,
one email. I have
yes. I'll
the next one email.
Lord,
my lord, I have
that's the crux of it. So log 9's obligation is not what I'm enforcing to the section 9 here. It is the respondent's obligation to make good this payment, and she very fairly does not dispute this obligation. Whether I take possession of the hypothecated vehicles and thereafter the claim will get
Before
adjusted.
the arbitrator, file your section
mitigate
7.
the loss, my lord.
That
They allow
mitigation
the
is an
loss to
aspect of
accumulate.
section 73. That will have to be tested on trial, whether a duty of mitigation.
Securing the awarded amount, my lord. That is what they are looking at.
Only thing is that what my claim is, my lord, if these assets also get dissipated, that injunction also be just considered one.
This is an injunction over the assets. I will not stand in the way. My lord passes an injunction because I have been asking them to take possession. My lord,
No, assets of the respondent.
the
They
assets
will
which
not.
are hypothecated in their favor,
No,
my
my
lord.
lord, that's a very circuitous way to go
That's
about it.
exactly what you're asking for.
No, Lordship, will look at my section 9 price once.
Yes. What are you asking for?
Page 15. Page 15. Come on, page 15, kindly have a look at. Press C, your lordship will consider. Because log 9 today has gone into CIRP. So these assets that were given to log 9, they know very, very well that I will not be able to get those assets. She does not dispute, her client does not dispute the obligation to make the payment to me. There's no point coming and showing the log 9 assets to me because that's in CIRP. I am not come against log 9.
Assets are mine. I am the owner. He is only a lessee. Even today, he can repossess, my lord. I can give him the details.
They can go ahead and say
100 three-wheeler cargo.
100.
So I will not go around.
Appoint a receiver.
No, that
my lord can.
His lordship can.
My lord can.
They'll take your.
That's one bit of it. The other bit is, the injunction your lordship will consider at C. Because if the agreement is not in doubt, the obligation to repay is not in doubt, the recourse clause is not in doubt, then this money, if it's not getting secure, at least let them not dissipate their own assets. Otherwise, the respondent will secrete all the assets. I'll have nothing left in the arbitration.
That I can't do.
And this is not a case, where I'm coming and actually just giving out figures without documents. I have their balance sheet on record. Their annual turnover is 36 lakhs. So the assets go. If I get an award and simplicity test of section 9, just to protect.
So Ashtia Corporate Private Limited, the respondents.
Yes.
In 41.
Yes.
Are not a party. In the first in 40.
In the first one, they're a party.
They're not. In first, it's only Ashtia Corporate Private.
But I am Ashtia.
Yes.
Yes.
That's her.
She's only the party.
That's the only party.
You are asking for security of the guarantor's assets, right?
That's in the second one.
That's in the second.
In this one, I'm asking for either or. I don't need both, which is why I said I'll take 5 minutes. My claim needs to be secured.
Yes.
I don't need to get against both.
Yes.
Either the surety, as in item number 42.
All you can get is your 100 vehicles, which you can, a receiver can be appointed. They can take care of it. Beyond that, nothing else.
These vehicles,
yes,
the entire vehicle, let us say your lordship appoints a receiver. He takes possession. Those vehicles are going to be sold. And then I recover. That will be an aspect of mitigation. The outstanding amount is not in doubt. If
I'm
today
disputing it. I'm
I'll just show
seriously
one
disputing it.
document, Your Lordship will just consider one document. Please have a look at.
So then let them file the reply, then we'll see that.
No, let them file the reply. I was thinking of a much easier way of you could have moved this by paper 17 and asked for a receiver there. But in the meantime, just one minute, page 174, please have a look at once of this brief.
I was in the next matter for the guarantee.
So Mr. Bose, what is your stand?
Lord, first thing first, my lord. There's no arbitration agreement so far as I am concerned.
With the guarantor. I'll just deal with that. There's a
Number two, my lord, if your lordship will see, there are four parties principally. My lord, the lessor was Ashitya. Then, my lord, the vehicles was leased to a company by the name of Log9. And thereafter, there is a surety, which is my client, which is Igaro. And thereafter, my lord, Ugro is the assignee, which is my learned friend's client, the present petition. So, my lord, the lessor had a right to receive the lease rent, my lord, from Log9. This was assigned by the lessor. The right to receive the lease rent was assigned by Ashitya to my learned friend, the present petitioner, Mr. Banerjee's client. Now, my lord, what we say is that, my lord, we stand discharged under section 139 and 141 of the Contract Act because this assignment was executed prior to the deed of guarantee executed by me. I gave the guarantee to the lessor that I guarantee the payment of lease rental by the lessee to you. And my lord, there was a specific clause in my guarantee agreement that you will put me on notice if you wish to assign. So what they did is they first assigned, then took the guarantee from me. So variance, I stand discharged. So at the ad interim stage, in any way, he is not entitled to any relief without affidavits. And in any event, my lord, so far
as you are concerned.
But may I just quickly respond to this? I'll first deal with the first application that your lordship is looking at. Lord, could I just show page 174 one?
Lord, so far as the arbitration, that point, I'll just indicate what is our contention. Well, Lord, the original master agreement, where all three were parties, admittedly, where I was also a party. The lessor, the lessee, and the surety. Now, my lord, if your lordship will see the guarantee, now their cause of action is that they have invoked the guarantee. And post invocation of guarantee, though the invocation letter is not a part of the section 9 application. Assuming that they have invoked because we've responded to the invocation, that's also a point. So based on that invocation, they're asking me as a guarantor to pay. Now your lordship will find in the deed of guarantee, my lord, there is no express. My lord, there has to be a incorporation not by reference. If it is an arbitration clause based on NBCC versus Zillion, there has to be an express indication that even the arbitration clause contained in the other agreement stands incorporated in the subsequent agreement. There is none. On the contrary, my lord, the clauses of the deed of guarantee requires him to put me on notice, which he hasn't. So based on the principle laid down by the Supreme Court in NBCC, it is our contention that there is no valid arbitration agreement between us and the petitioner, which is the assignee of the lease. And my lord, one more aspect, my lord, your lordship, it fell from your lordship on the vehicles. Well, your lordship will be surprised to know that Log9, by a letter in March, as long back as in March, before they went into CIRP, they called upon them to come and take possession of all the EV vehicle, 100 EV vehicles. This was 6 months before they went into CIRP. So, they have done nothing. They have not.
Just quickly respond to this. May I just quickly respond to this? 174, apropos the first one. The second one, the law has changed a bit now. I'll cite that Supreme Court decision.
So what are you showing on 174?
174 is the balance sheet of this respondent, who my learned friend is appearing for, item number 41. Please have a look at the net worth of the company. It's 36 lakhs. And the gross fixed assets, including tangible, intangible assets, is about 60 lakhs. And depreciation and amortization is So it's about 60 lakhs what is there. But your lordship will appoint a receiver. Kindly does that to take possession of these vehicles. Now both of them come and say, take the vehicles and sell. That can happen through a process of court. In the meantime, if this is the financial substratum of the company, well put together, it's not even 36 lakh net worth, forgets it. 60 lakhs is all that the company has. In the event I succeed against Ashitya in the arbitration, because there is no dispute with regard to the amount payable, my learned friend very fairly submits that the clause is there, the agreement is valid. And I'll show that recourse clause that this is her obligation unto me. It's a very simple case where I have taken on the lease rentals from X. X has defaulted is an undisputed position. That money I'm going to get. Today I'm standing in before your lordship with the security not enough to cover that award. That much your lordship will kindly appoint the receiver, and I'll deal with Mr. Bose's argument in a second after. Kindly appoint the receiver over all the vehicles. We prayed for that. And in the meantime,
we'll have it after lunch.
Very well. We'll come back and
just call Mr. Shaunak Mukhopadhyay. Very good.
Shaunak Mukhopadhyay.
I just saw him. He's supposed to report back.
My lord went. And I had a talk with his senior officer.
Yes, what happened? Yes.
They will take some instruction from their clients.
They have
So
not
they have
taken.
requested for next week. My lord, next week on Monday, Mr. Shane is not available. So next Wednesday I was coming.
Order. This is item number?
My lord, it's item number
31 and 32, my lord.
31.
31, 32, keep it for Wednesday. Let them
Great.
take it. 31,
Obliged.
Wednesday.
Very good. telling him, he sabotaged me just before I started my argument. Very innocuously, he gave me a clove, which I had, and then I'm finding it difficult to
refined arguments.
But I was dealing with the arguments that were advanced by what have you done? Lord, one thing your lordship has seen, the net worth of the company.
You better go before the arbitrator. Better.
No, that I will. If the respondent in item number 41 agrees, I'm sure he will take the point of arbitrability, but he's taken that point. I'll deal with it right now. But against him, I'll have to file a 11. But before I go to the arbitrable, one thing your lordship will kindly appreciate. Log 9 has a leasehold interest over these electric vehicles. Log 9 is in CIRP. Because of the moratorium, I will not be able to proceed against log 9. So this respondent plays it very safe by saying, go take the vehicles. I will not be allowed to. The law prohibits me from doing that. And also at the same time, they don't come and dispute two things. One is the obligation to repay and the quantum. What I wanted to show to your lordship was the turnover of this respondent item number 41. Mr. Bose's client, I'll come to in a minute. The turnover is 31 lakhs.
Page 174.
Page 1, your lordship is right. Page 174 and 187 is the turnover. 31 lakhs. So when the obligation, the agreement is admitted, the obligation to repay is admitted, the assets are not available because now log 9 is gone. Leasehold interest section 14 protects them. With the CIRP, there's a moratorium. I will not be able to ask your lordship to pass an order which is contrary to law. ACPL might come saying, please appoint a receiver over. So all that I seek is, while this arbitration, your lordship will appoint an arbitrator here and now. But pending that, there be injunction at least on their bank account and the assets of the company, because the assets of the company are worth 59 lakhs. They have nothing. And apropos item number 42. That item number 42, two things he argues. One is incorporation by reference of the agreement. Therefore, there is no arbitration clause against me. So that I'll just show. One thing your lordship will just consider.
And my lord, apropos that, one additional argument, the invocation is bad because the master lease agreement contemplates certain preconditions before invocation. So the invocation is not in terms of the agreement.
Your lordship will just once have a look at item number 42. এটা কোথায় গেল যে এটা ও জানি নাই ওটা কোথায় গেল?
Tell me what you want, Alex.
Your lordship will please have a look at the agreement which starts at page 26. No, a guarantee agreement. Sorry, I'm sorry, my lord, the deed of guarantee. At 77, that everything is going to be. Page 77, clause 5. After the clove, I refuse to trust you. Clause 5, please see facility agreement, master operating lease agreement, executed between the lessor, the lessee, and the surety guarantor on 6th March, hereinafter referred to. The same shall be an integral part of this deed of guarantee. Because this law apropos incorporation by reference of an arbitration clause has gone a paradigm shift now. One thing to say that the agreement is being referred to. The other is to say that all terms of that agreement are being made a part of this. In such a fact, may I just formally, for the sake of completeness, refer to this. This is 2026 SCC Online SC 854. Here also your lordship will find that not the original agreement holders or parties to the agreement had come. But this issue came up for consideration. Paragraph 9, MR Engineers is considered. Somdat Builders. Now your lordship will see how the law has developed. Paragraph 11, please see. 10 onwards. I'm sorry, 10. Again, in NBCC versus Zillion, this court held that an arbitration clause in another document would get incorporated into the later contract by reference if the contract contains a clear reference to the document containing the arbitration clause, and such reference to the other document clearly indicates the intention to incorporate the arbitration clause into the contract, and such arbitration clause is capable of application to the disputes under the contract and is not repugnant to any term of that contract. This court clarified that a general reference to another contract would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. Applying the aforesaid edict, and in particular the illustration in paragraph 17 of MR Engineers, we find that this was not a case of mere reference to an earlier document containing an arbitration clause. The later permanent alternate accommodation agreements entered into between the appellant with the respondent members unequivocally recorded in clause 14 that all the terms and conditions of the development agreement shall be construed to form a part of the said agreement, and all clauses of the same shall be binding on the parties to the later agreement. I've shown that, my lord, it is identical to the clause that is before your lordship at page 78. There could be no clearer indication of the intention of the parties to incorporate and assimilate the development agreement dated 4th July in its entirety and into the later permanent alternate accommodation agreements, not stopping short at asserting all terms and conditions of development agreement should be construed to be part of the permanent, and then this is what is there. Here also the language is same, that it specific reference, all terms are coming in and it is binding. Now the other aspect which is argued is with regard to assignment. My lord, please have a look at the main agreement once, and I'll end here, my lord. Your lordship will please once look at page 23, the agreement starts.
In item 42.
Now I'm dealing with Mr. Bose's
Page.
for 24. Because he's fed me the clove and
Yes.
page 24. Ashitya Comrade, this is the respondent item number 41. They have assigned this to me. This is the parent agreement where Mr. Bose's client is the guarantor. Ashitya Comrade so-and-so, lesser, which expression will, unless repugnant to the context or meaning thereof, mean and includes its successors in interest and permitted assigns. Now, there's a specific clause which allows assignment. Such a clause came to be considered by your lordships, and it has been held that if I am an assignee of that agreement or a successor in interest, which admittedly I am, then the arbitration clause I can take benefit of. So, my lord, I'll cite that decision. This is reported in 2024 SCC Online Calcutta 7464. Just one paragraph I'll cite, my lord, in this. Your lordship will see the discussion starts from 24 and Cox and Kings and all that is considered. Impossible to do a matter. 32, please see. Thus, not only were thus not only were all the then flat owners within the fold of the contract, but the respective successors in interest were also included under the definition of flat. Oh, I'm sorry, my lord.
Yes, yes.
May I? Flat owners, which was the second party to the agreement. The use of the expression successors is sufficiently expansive to include all subsequent successors in interest of the then flat owners, including the present petitioners. My lord, arbitrability is something when I come under 11 is the existence that your lordship will examine. Prima facie, I am showing under section 9. There is an agreement, tripartite agreement between ACPL, Log 9 and Mr. Bose's client. Mr. Bose's client's job, if I may use that, is actually to give guarantee and surety. That is what the company does. All that I'm praying for, my lord, if they want to file affidavits, they can. If your lordship can somehow cajole Mr. Bose to agreeing, and and if she agrees on item number 41, an arbitrator can be appointed here and now. But pending this, ACPL or ICARO, one of them will secure this debt, because ACPL actually has no assets, and today I'm at an ad interim stage. So whatever I have come up with, my statements are to be taken to be true and correct, and I have their own documents here. The balance sheet is ACPL's balance sheet, with 31 lakhs as the turnover and 59 lakhs worth of assets. And my claim and the obligation to pay is of 4 crores. The leased assets are gone because log 9 is in CIRP. So at this stage, if they want to file affidavits, let them. I can't come in the way, but your lordship will consider prayer C in my section 9 in the item number 41. Or similar prayer against Mr. Bose's client in item number 42. Just to secure it. Then we go there, fight it out, and discharge by variation. But it is not a point that he can argue in my section 9. It's also a complete question of fact which has to be tried. Discharge by variation of a surety is of a threshold which requires its highest test, because he admits the existence of the agreement and then he says, for variation I'm out. That variation has to be proved, for which there is an arbitration.
Financial report for the year 2020.
Mike, take the mic.
Take the mic.
This was the financial report for the year 2023-2024. Factoring agreement is of 2024. So this is the report on the basis of which the facilities were advanced. There is no allegation that this position has undergone a change. This was found to be commercially viable to advance substantial amounts under the factoring agreement. My lord, there is no allegation or no cogent evidence to show that I have dissipated any of my assets. Nothing to show I have siphoned off my assets, my lord. My lord, although my lord, Order 38 Rule 5 may not be stricto sensu applicable, the principles, my lord, in my humble submission will have to be followed. Sanghi Industries I have. I'm not placing, my lord, but I have it with me. Well, so far as the quantum being admitted is concerned, and I'm not admitting the quantum. On the other hand, I am saying, if steps were taken as early as in January 25, I have emails galore to show. My lord can look through the emails. I have written to them. Log 9 has written to them. My lord will recollect September 2025 is when CIRP starts. From January 2025, there are more than 15 emails telling them kindly take possession because we are not in a position to pay. And my lord, there were joint meetings held also. At the moment, I do not have the minutes, but there are minutes also of those meetings, my lord. So, my lord, they have not come to court with clean hands. This is an equitable remedy. If they have to avail of this remedy, these emails are not on record. Only one email, which is annexure I, is on record. From there, my lord will find out that log 9 offers to surrender. They do not receive.
Did you issue a section 21 notice?
Yes.
When?
21 notice also. 5th of March. In this matter, Lord, 5th of March 2025. 2026, 5th of March is there. And while your lordship has put that query to me, there are no minutes. If she produces that, I'll withdraw my section 9. There are no minutes. No meeting with her minutes saying I will take back. I can't. That log 9 is in CIRP. One thing your lordship will please have a look at page 57 of item number.
I'm not saying they agreed to take back. I am saying there are requests to take back.
It's in CIRP, how will I take?
These are from January 2025 to September 2025. September 2025 is the date when CIRP starts. These are all prior to that. They do not do that. They allow the losses to accumulate. There has been minutes held, my lord. Kindly allows me a short time to file an affidavit. I'll bring all documents on record. My lord may peruse the documents. My lord, from January 2025, in my most respectful submission, if this has been going on, my lord, in 2 weeks, my lord, allowing me to file an affidavit, putting on record all the documents, my lord. But in Order 38 Rule 5, the criteria have not been fulfilled, my lord. I have not been shown to be dissipating my assets. While Learned Friend relies on a financial report of 23-24. He doesn't say my position has deteriorated since 23-24. But 38 Rule 5 has to be fulfilled in my humble submission, my lord. And quantum, my lord, is much less, my lord. If the vehicles were sold at the appropriate time, quantum would be much less. Even today, there are 100 vehicles, my lord. I'm not saying that a receiver may not be. A receiver be appointed, my lord. These are his secured assets, my lord. He has a first right as a deed of hypothecation, under a deed of hypothecation, which is also on record before your lordship. He can get those vehicles.
They don't know.
And in November also, I have intimated him the location of 30 vehicles. He has not taken possession of that.
Look, my learned friend wouldn't know. My junior was part of the settlement meeting. ACPL or log 9 don't know where these vehicles are. They were further subleased and what condition they are in. These meetings have all failed. And now, my lord, I really, with some confidence, I can indicate that I can't really beseech your lordship to pass an order of receiver in my favor in respect of the assets. It's something that's contrary to law. I will not do it for a matter. It's hit by section 14 of the code. Not one thing your lordship will have a look at, please, at page 57. And I'll not trouble your lordship with item number 41 anymore. Please have a look at page 57 once of item number 41. And order 38 rule 5 principles apply. She's entitled to file an affidavit to show cause. I am on an injunction. The basis is different. 38.5, she will have a time to show cause. In fact, without a show cause, I can't. Please have a look at the recourse clause at page 57. This is in the agreement between me and her. Recourse means the right of the petitioner to require ACPL at any time forthwith upon notice to pay to the petitioner an amount equal to the amount remaining unpaid by log 9 in respect of any matter.
As far as this is concerned, 41 is concerned, we can send you to arbitration.
My lord.
All right. We'll treat it section 9 as 11. Refer you to arbitration. Move your section 17, or this can be treated as 17. Do whatever you have to do before the arbitrator. I'm not passing any orders. As far as 42 is concerned, probably he has an objection to that there is
To the arbitrability.
Let him file his affidavit.
Let him, lordship does this. In the interregnum, at least for 7 days, give me some protection.
What protection?
If I'm going before the arbitrator in item 41.
Since March, you have issued a 21 notice. Nothing has happened. There's no question of any interim protection.
Well, then at least that position be maintained. Let my learned friend say that. Not Mr. Bose's client. Let in item number 41, the respondents say that we will not alter the position for the next 7 days. That's all. Let that statement come that for 7 days I will not do
I cannot on my own make any statement.
Then,
But I
for
don't-
7 days, your lordship will give me that protection.
7 days anything will happen.
Since March, they have not done anything. There's no reason for them to do it in August. Literally August.
Let this also go down. Because there's a reason why I mentioned the matter and I'm pressing this. Log 9 having gone into CIRP, the entire position now changes.
Whatever it
What
is,
happens is,
See,
I'll take it up in 17 before the arbitrator.
take it up.
Yeah, and I'll do it within the shortest time, and your lordship will allow me to treat the 17, this section 9, as a 17 with all my reliefs there. In the meantime, at least kindly observes that they will not alter the position in the next 7 days, my lord. Otherwise, I don't have the assets.
They have not done it. There's no reason for this court to feel that they will do it, because if they have not done it since March,
May I then just pray for,
January.
I understand. May I then just pray for this?
Yes.
This expectation, if your lordship could just mention.
So why
That
should
it's
I?
no, my lord,
Why should I be
otherwise,
prejudicing the learned arbitrator.
no, that your lordship can say that he will not be influenced by anything.
No, why should I?
Well,
Why, from January, they have not done anything. Why will they do it now in 1 week?
well, I don't know what they have done. From January, I filed this in quite some time back.
Test it. I will allow them to file their reply. Then it will go on. I am not giving you
No,
anything.
no, my lord, I'm not on that. This is the best way out, that I go before the arbitrator. But this application has been pending for quite some time. I have come on time. What has happened in the interregnum, I don't know. So during the
Whatever will
pendency
happen
of the list,
What has not happened will not happen in 1
that is all I'm saying. That
In
what has happened has happened. That I can't help now.
I'm not giving
But
that
as
protection.
your lordship is considering it today,
I'm not giving that protection to you that nothing should change. That amounts to literally giving a blanket stay. I will not do it.
well, two things I'm being able to satisfy you, to your lordship. One is that the financial substratum of the company is in doldrums. My claim exceeds that.
Change. In 1 week, nothing is going to change.
So that is all that I'm praying for, that your lordship will send me there. But record that in 1 week, they will not change this. Well, if that is gone, the assets also gone, I'll be left with nothing in the arbitration.
Let them file their reply. I'm not granting you any relief right now. Let them file their reply. We'll see it. We'll see what
So
will.
far as this argument of Mr. Banerjee
A
regarding
second, with 41,
CIR
my lordship will send me to arbitration, treating this as a section 17 application and appoint an arbitrator. I'll go and try my luck there.
well, so far as the CIRP argument, well, it is wholly misplaced.
42, let him file an
They
affidavit.
were always the owners. They continue to be the owner. CIRP is of the lessee. He is not the owner of the assets. So there is no impediment under the Insolvency and Bankruptcy Code for you to take steps.
Leasehold interest, that's under CIRP. That's absolute.
The lessee has surrendered his leasehold interest in March.
Thrash it out before.
Yes, madam.
Yes, then let him appear to an arbitration.
At the outset, learned counsel for the parties submit
In 42, let him file an affidavit. 41 will.
that the present petition. At the outset, learned counsel for the parties submit that with the consent, an arbitrator can be appointed, and the present application under section 9 shall be treated as an application under section 17 before the learned arbitrator. Full stop. In view of the same. Yes, tell me the name. Who do you want as an arbitrator?
Whoever, I have.
What is the amount involved?
It will be about around 5-6 crores. More than 5 crores. Mr. Amitesh Banerjee is my brother.
Then who should we appoint?
Anybody. Point him on best person. He knows the matter also, can go to him tomorrow. We have no objection. Mr. Shamrat Sen.
Mr. Shatrughat sitting over.
Mr. Shamrat Sen, Your Lordship.
Mr. Samrat Sen is senior counsel, right? He's a senior.
Senior.
Mr. Samrat Sen, senior advocate, appointed as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter a reference in due compliance with section 12 of the said act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule of the act or with the consent of the parties. Full stop. With the aforesaid direction, the present petition stands disposed of. This goes for 41. 42. The petitioner has filed the present application under section 9 of the Arbitration and Conciliation Act, seeking interim measures of protection pending before the pending the arbitral proceeding. Full stop. Learned counsel for the petitioner submits that the Asia Comtrade Private Limited as the lessor entered into a master operating lease agreement with Log9 Mobility Private Limited as a lessee for leasing 100 electric three-wheeler cargo vehicles. It is submitted that the respondent Equero Surety Private Limited executed a deed of guarantee in favor of the lessor, guaranteeing the due performance of the lessor's obligation under the lease agreement. Full stop. Subsequently, the lessor assigned its present and future receivables arising under the lease agreement in favor of the petitioner under a master factoring agreement, whereupon the petitioner became entitled to receive the lease rentals. Full stop. It is further submitted that a deed of hypothecation was also executed in favor of the petitioner over the leased vehicle as a security for the assigned vehicles. Full stop. It is the case of the petitioner that the lessee committed defaults in repayment of lease rentals, in payment of the lease rentals, and was thereafter admitted to CIRP, right?
Yes.
Corporate Insolvency Resolution Process by the National Company Law Tribunal. Which one?
Bengaluru bench.
Bengaluru bench. Full stop. Consequently, the petitioner invoked the corporate guarantee furnished by the respondent by issuing a demand notice calling upon the respondent to honor its obligation under the said deed of guarantee. Despite such invocation, the respondent had failed to make any outstanding payment. Full stop. the petitioner thereafter invoked arbitration by issuing a notice under section, you have issued a notice under section.
Yes.
By issuing a notice under section 21 of the Arbitration Conciliation Act dated
Fifth, March 5th,
of
2020.
2026.
So that's
At
the
this stage,
invocation of
learned senior counsel for the respondent,
March 15th.
Mr. Moinak Bose, seeks leave to file affidavit in opposition. Full stop. The respondent, learned senior counsel for the respondent, disputes its liability under the
And my lord, I challenge the maintainability of
guarantee deed. Guarantee deed. Full stop. He also challenges the very maintainability of the present petition on the ground that the respondent is not a signatory to the arbitration, to the agreement, and hence the arbitration clause cannot be invoked against the respondent.
but not expressly incorporated in the deed of guarantee. So his
The respondent's
claim arises out of the deed of guarantee.
maintainability, उसमें कर देना, he challenges the maintainability of the present petition on the ground that the agreement, the guarantee agreement, does not expressly incorporate the arbitration clause as contained in the lease deed. Full stop. Considering the nature of the controversy, the respondent is directed to file his affidavit in opposition within a period of
2 weeks.
within a period of 2 weeks. Reply to the same, if any, within 1 week thereafter, list after 4 weeks. 2 weeks, 1 week, 4 weeks.
In item 41, your lordships converted this section 9 into along 17.
7.
So could it be 3 weeks, my lord? My goodness.
3 weeks, 1
Grateful.
week, 4 weeks, 5 weeks. After 5 weeks.
Oh, wait. Item number 41 and 42, the affidavit of service and notice of motion. Wait.
हाँ कौन सा? Yes, 33. Where is he?
Mixer 2 PM, item number 33.
I'm virtually connected, my lord.
My lord. Yes.
My first, my lord, on 4th of February, my lord had recorded an order. On 4th of February 26.
Yes.
4th February order, my lord will find that my lord had noted that they are taking this stand. My lord will see second, third para, conduct of the respondent is deprecated as in making misleading submissions before both the council as well as the court. Then my lord will see after that, my lord had clarified that the pendency of the present application will not operate as a stay of the proceedings before MSME council, and council will be at liberty to decide the pending application under section 17. Now kindly see, my lord, after that, on 22nd June 26, my lord, again a statement is made on behalf of the respondent.
What happened, Mr. Ganguly?
Supplementary affidavit.
My lord, hearing has been done. They need certain clarification. We have given the clarification yesterday, and they have accepted it. They said that they will pass order. They have said verbally said.
This can there be expert?
There.
He's here. He has
the
received no
lawyer.
communication.
No, are you the lawyer, sir, who's representing your client before the council?
Yes.
What has happened yesterday?
It was last taken up on 30th January 2026.
Yes.
There was a hearing done, but it was not concluded. They had given a date. In fact, in the order, my lord, the last line in the order says it is decided to take up the matter later on.
So there is no change of circumstances.
No order was.
You are saying, Mr. Ganguly, the matter was heard
They have
yesterday.
said, they have verbally said that we are going to pass an order. We need some
Mr.
time.
Ganguly, you said the matter was taken up yesterday.
No, taken up now. They have asked certain clarification from
When
our end.
did
There is a typological error. We have prepared it and we have deposited it.
When did you do that, Mr. Ganguly?
Yesterday we went there.
Every date, nothing on record.
You went there.
Yes.
Who was there?
Me and my junior both.
No, there is no, we have filed a supplementary.
Yeah,
affidavit.
they have
Nothing has happened, my lord. This is
they have
absurd
said,
on
my
every
lord,
day.
they have called us.
Matters
They
are
have
taken
called us.
online. How is he going
How
physically?
have they called you, Mr. Ganguly?
Over telephone to my junior.
The
On
council,
the last date, I have said that on the last day they have called us. And we went there yesterday. And they have said that there is a typological error. We have to be corrected. And we have taken note of that. And they have asked that by Monday we have to be given that corrected copy. There is a one typological mistake, my lord. On Monday, next Monday.
Can a court or authority communicate with one party?
calling you over telephone.
Over telephone, they have asked them to come. Yesterday, my junior went there. They've said that
Why
there is
are
a
they calling
typological.
only? Why are they calling only one party? They have asked you
No,
to
no,
come.
there is a typological error. They have said that you make it corrected and send a copy to them and also give a copy by Monday.
What error?
But there is a typological error that the one quantity of the materials, that is the point. One point is there that is placed in another. There is a 42 kgs, that will be 422 kgs. That is the only. They have asked me to give the clarification of that corrected copy, and after serving them, we have to deposit it by Monday. They have said us.
We have written, kindly see supplementary affidavit, page 11. On 23rd June, we have written to the council.
And by Monday, we are going to deposit after
And the
serving
council
copy
is
to
a
them.
formal letter written to the council intimating this honorable court's order. And my lord, we are asking them to inform the present status. Is it conceivable that council does not respond to us and calls him up and seeks clarification? What is he saying, my lord? It's not. I can't believe that a quasi judicial authority can function like this.
The department has called. Not the authority has called.
Then
why would the department call Mr. Ganguly?
Well, the department has called my
they are
junior.
not taking up the matter and passing an order?
2 or 3 orders passed by this court in
I don't know.
different
The
proceedings.
authority has called us. We went there. We have paid the respect. We went there and they have said that after serving a copy to them, we have to serve the copy upon the authority.
Yeah, you should have filed a writ petition.
There's an order in a writ petition asking the council 1 year back to decide in 3 months.
Then you should have filed a contempt.
Against the judicial authority, my lord. How?
If there is a direction which is passed by the writ court and
My
not being complied, what do?
So we filed initially a section 9, then the court said you try 17, and then if 17 doesn't work, then you file again section 9. That's what we have now done. So
my problem is your petition is already pending before the MSME Council. To assume the same jurisdiction and to pass an order under section 9.
I had placed that judgment 2025, my lord, where it is not efficacious remedy. There, my lord.
It is not efficacious remedy. 2 similar proceedings can't lie. One before the arbitration council, one before me.
That judgment, my lord, last time I had placed, my lord. If that judgment.
When if I go on that judgment? Very difficult. Immediately this will be stayed if I pass an order. This will be set aside.
My lord, there are 3 orders passed by different your lordship's courts, my lord. How can the council ignore it like this, my lord? My lord may pass then a direction.
That is the reason why you should have gone in contempt, sir.
My lord can pass as my lord is still supervisory. Kindly see
jurisdiction.
I appreciate
not a supervisory court.
That Arcelor Mittal, my lord, Supreme Court has said that limited order of interim protection. My lord,
please understand, I am sitting here
no,
in
I
section
appreciate.
9.
Yes. So
not a writ.
No, I appreciate. So, my lord, this judgment I was reading, Arcelor Mittal, Supreme Court says section 9 may be passed.
He is making full use of it, nothing else.
That section 9 may be passed in a situation where section 17 is not efficacious or the authority is not taking it up. Kindly see para 98 of the judgment, my lord. I placed it. Kindly see 98.
Yes.
Kindly see para 19. It is reiterated 98, which is on the last page. The section 9(1) enables the parties to an arbitration agreement to approach the appropriate court before commencement, during, or at any time after The bar of 9.3 operates where application had not been entered. Of course, it is hardly need to be mentioned. Even if an application under section 9 had been entered in before, court has the discretion to direct the parties to, if necessary, by passing limited order of interim protection. Now, kindly see after that, particularly when there has been a long time gap between hearings, and application has for all practical purposes to be heard afresh or hearing.
Before the arbitral
Yes, yes.
proceeding.
Now, kindly see para 86, my lord. Para 86. 73. May I just place the paragraphs? Kindly see para 73. Para 73, that's wrong. 733, my lord. Kindly see. In Energo Energy Projects Limited versus TRF, then a harmonious reading of 9.1 read with 9.3 makes it amply clear that even after amendment, court is not denuded of power to grant interim relief once an arbitral tribunal is constituted. When there is an application for interim relief under section 9, court is required to examine if the applicant has an efficacious remedy under section 17 of getting immediate interim relief from the arbitral tribunal. Once the court finds that circumstances exist that may not render the remedy provided efficacious, court has the discretion to entertain an application for interim relief. Even if a tribunal is not functional for a brief period of time, an application for urgent interim relief has to be entertained by the court under section 9. Then kindly see bottom of the page. An application for interim relief should ordinarily be decided by tribunal once an arbitral tribunal is constituted. However, if circumstances exist which may not render the remedy under section 17 of the 1996 Act efficacious, court has to consider the prayer for interim relief on merits and pass such order as the court may deem appropriate.
All right, you have been contesting section 9. What about section 11? What has happened? What steps have you taken?
No, this is the section 11 is the proceeding, my lord. This is the MSME council. That is the arbitration. It's going on.
Proceedings are going
Yes,
on.
yes.
Hearings are happening.
Yes, no hearing. That was the last hearing, 30th January 2016.
After 30th January, nothing other.
No hearing. We have written to them repeatedly.
One day was fixed. Thereafter, they have
No
postponed the hearing.
intimation to us. No communication to us. How can what is my learned friend submitting? Kindly.
When was it fixed, Mr. Ganguly?
No, 30th January. Thereafter, one day has been fixed, but that date has been postponed. But thereafter, they called us and they asked for certain clarification and asked us to submit it on by Monday. After submitting the copy to the Vatsal packaging.
Kindly see para 87. Even after an arbitral tribunal is constituted, there may be myriad reasons why tribunal may not be.
Where's the writ order?
Yes, madam. Kindly see page 110 of the section 9 petition. Now the writ order. My lord is asking for the writ order.
Section 9 was filed on?
The first section 9 or the second one?
Second one.
Second one was the date of filing of this petition. My lord, the writ, I'll just give the date. Just give the date of the filing of the
First was dismissed for
June
default.
2025.
No. First, we filed a writ petition. That order supplementary affidavit, page 6.
No. The first APCOM.
We filed that. The learned single judge said that you try 17 first.
No, dismissed for default.
That was second time. This was the same proceeding. First, kindly see the chain of events is like this. First, we filed a writ. That order supplementary affidavit, page 6. Kindly see that for a moment. Kindly see the writ petition order. This is my lord had page 6 of the supplementary affidavit. It fell from your lordship regarding the writ petition. Then kindly see it records an application is made by.
First, you had filed supplementary this writ petition, right? First one.
No, the first order is the first section 9 order, but my lord posed a query regarding the writ.
The chain.
Yes, chain is first is order. Kindly see Justice Shampa Sarkar's order 8th April 2025. That my lord will find page 110 of the section 9 petition.
This is your first?
Yes, first section 9. This is an application under section 9. This court is of the view that application is not maintainable. Petitioner had filed an application under section 18. At this stage, Mr. Banerjee submits application will be withdrawn with liberty to file afresh. This court is of the view that upon failure of conciliation, Arbitration and Conciliation Act applies to a proceeding under MSME Act under section 83. The council or such other institute appointed is to initiate an arbitral proceeding. Then kindly see after this, the next page, after that portion is set out, remedy of the petition for interim protection would be under section 17. However, Mr. Banerjee submits that such procedure may not be efficacious. At this stage, it is not proper to adjudicate on this issue, as there is nothing before the court which would indicate that the remedy available in the arbitration proceeding has been proved to be ineffective. The application is dismissed as withdrawn. If at all such situation so arises, which would render the remedy under section 17 inefficacious, petitioner may approach this court strictly in accordance with law in the event there is a subsisting arbitration agreement. So this is the first order. Then my lord may kindly see Justice Amrita Sinha's my lord order at page 6 of the supplementary affidavit.
Yes.
An application was made by the petitioner for settlement of dispute before the Micro Small Enterprises on 18 July 2022. The petitioner alleges said reference has not been disposed till date. Reference has been made under section 18(5) of the MSME Development Act, which prescribes 90 days as the time limit for disposal of the reference. The said time period has long expired. In view of the above, the instant writ petition stands disposed of by directing the respondent number 3 to take immediate steps in accordance with law for disposal of the reference at the earliest but positively within 90 days from the date of communication of this order. So this is the direction on 27th August 2025. Then, my lord, we have filed the section 17 is pending before the council.
No, wait a minute. This direction is for them to entertain your
Complete, full thing.
full thing.
Full thing, yes.
So this is 18(5). Your reference under 18(5).
Yes,
right?
yes.
So that was entertained.
No, to dispose of the whole proceeding is to be disposed of. It is the whole arbitration award has to be passed. That is the requirement.
Show me the
Section 18(5) MSME Act. মানেটা কত আছে Section 18, my lord. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under Section 17, make a reference. On receipt of a reference, council may either itself conduct conciliation in the matter or seek the assistance of an institution or center providing alternative dispute resolution services by making a reference to such an institution or center for conducting conciliation, and provisions of section 65 to 81 shall apply. Where conciliation is not successful and stands terminated without any settlement between the parties, council shall either itself take up the dispute for arbitration or refer to it any institution or center providing alternative dispute resolution services for such arbitration, and the provisions of Arbitration Act shall apply to the dispute as if the arbitration was in pursuance of an arbitration agreement referred to in subsection 1 of section 7 of that act. Notwithstanding anything contained in any other law for the time being in force, Micro and Small Enterprises Facilitation Council or the center providing alternative dispute resolution services shall have jurisdiction to act as an arbitrator or conciliator under this section in a dispute between the supplier located within its jurisdiction and a buyer located anywhere in India. Every reference made under this section shall be decided within 90 days from the date of making of the reference. And we had already.
So the reference has been treated as it was not resolved, then they have referred it to the arbitration. That's a procedure, right?
They can either do it themselves or they can.
18(4).
Yes. So in this case, they had already taken it up. Conciliation had failed. It was already being taken up, my lord, for arbitration, but it was not being disposed of. So which is why we approached the court, and the court passed. Kindly see, just to make it clear, my lord, may have page 96 for a moment of the 98 of the section 9 petition. Kindly see. This is, I appreciate what the query which is falling from your lordship. Kindly see page 98.
See, you have been trying to get a relief from this court. The first round also you have been kicked out of the court. The second time also you are coming here with a similar relief. Nothing else. A section 9 you are filing here. You are not getting anything in 17. You are having this apprehension from the day the first order was passed. And that is the reason why it has been recorded that on page 111, the remedy for petition for interim protection would be under section 17. You have been rejected.
But the court has said that
you
in
have been
case
thrown out of the court on that day. giving you the liberty that you can come here,
Come
you
back
go
if there-
before the council.
So we have
The
got,
council is not passing any order. You come before the writ court. The writ court has given a direction.
that is not being hide.
You failed to file a contempt. You have done nothing as far as the writ court's order is concerned. You have again come in section 9 seeking the similar relief which you have failed to get.
But my
On
lord,
8th April 2025, seeking same relief
that
in July of 2026.
that order itself says that if it is not efficacious, we can come back. We don't have any, my lord, we today what is, we do not have any remedy because
Have a remedy.
they are
You could
not
have got
taking
a
up the
direc-
matter.
You could have got a direction. You have not done that. You have again filed a section 9, though your section 17 is pending, trying to get a relief from this court.
Because my lord, my section 17 is not being taken up, my lord.
I'll ask them to file their reply and all that. Let them file their reply.
They have filed. They have filed.
All right.
They have filed their opposition on merits.
We'll hear you on some other day. For 1 year, you have been hovering here and there. And how many times you have written to the council?
20 times almost, my lord. We've written almost 20 times.
File a contempt also. That's much better for you. Not today. Supplementary affidavit is filed today. You're filing the supplementary today?
Yes, yes.
Supplementary affidavit filed by the petitioner is taken on record.
I will collect the copy from them, my lord.
Give a copy.
I will collect the copy from the advocate on record.
Supplementary affidavit filed by the petitioner is taken on record. Lays the matter after 2-3 weeks. We'll hear it after 2-3 weeks. We'll see. I know what will happen. I'll pass an order. This will get set aside. Nothing else is going to happen. After 3 weeks.
Will be allowed to leave.
Yeah. Once up.
At 3 p.m. at number 72.
This is that matter.
May I please, your lordship?
Yes. Why we have fixed it? Hearing?
Yes.
Yes,
Today, the award has been passed on 2005.
No, it's the second round of litigation, my lord. The
But that matter which your lordship was pleased to fact.
Initial
this is the
order-
matter against which appeal has been preferred. We are the award holder. Section 34 dismiss. Against that, they have preferred an appeal. The appeal court treated that since in 2015 Commercial Act has come into force, and on that basis, since the court has not treated it as a commercially, so it has been. This is the order, lordship. If you lordship kindly see the order itself.
the order was given on the last date also.
Lordship kindly see the order passed by the division bench. It has to be disposed of expeditiously as possible. It has been.
Establishments.
Yes. What is this? What are you
Yes,
trying?
Lord,
This is
this
the
is
last division bench order. Probably it is before your lordship. That is the order passed on February 2, 2026.
Lord, initially the appeal was heard, the award was stayed, my lord, and thereafter, my lord, it was basically heard by, my lord, 3 consecutive benches, my lord. The matter could not be concluded there. Finally, my lord, it was disposed of by the Honorable Division Bench, my lord, of Justice, Honorable Justice Devanshu Basa, inter alia, my lord, setting aside the order on the ground that the Section 34 court, which has, my lord, rejected the Section 34 application, had no jurisdiction because it should have been heard in the commercial bench, commercial side. And we have also argued the matter on merit, my lord. After arguing on merit, we have
They
got the
didn't take
stay.
it on the.
Yes, my lord.
This was challenged or challenged?
I tell you, lordship.
It was not challenged. In SLP, it was not. They have
Not
not.
challenged.
No,
Not
they have not come. In another matter, my lord, your lordship is right. In another matter, my lord, this kind of order was
Yes,
I understand.
it was challenged, right?
PAM developers. In PAM developers.
Correct.
They have not challenged.
So that is, my lord, right now binding, and my lord, de novo hearing has to be given, my lord. And my lord, I will show that the award was patently, my lord, the portion, because my lord, the cap of prejudice, my lord, which has been, my lord.
This has changed to the extent that if the
Yes,
the order is not passed on the commercial side, it can't be just dismissed like that.
it was done before the order comes. Before the Supreme Court order, my lord, it was done.
It was done
I
before.
will be very candid, my lord.
I
That's true.
must be. Yes.
That's true. My learned friend has not preferred any SLP. We are lucky on that. In any event,
I have
my
a talk with my client. Client says that I don't want to say that, let the matter be disposed of. I understand, but this decision has been come thereafter.
yes, yes. Similar orders were passed.
But
my
this
lord,
is
in-
a very precarious situation
In
which
fact-
my client is facing from pillar to
But
post.
precarious situation
My
for a
lord,
single
my lord.
single bench also.
Single bench, yes. Single bench in 1990. This section 34 application has been taken out in 2006 January. The award has been passed on 31st of December 2005, and thereafter the matter this.
Mr. Roy, the division bench has passed an order stating it should have been heard on the commercials.
Commercial bench. Only on that point.
Only on that point it has been dismissed. Now that issue is settled. Isn't
But,
it?
but my lord, in another matter, my lord, it's
In
no
another
doubt.
matter, it is settled.
Yes.
Now,
But my lord, the order passed in a my lord, inter-party dispute that binds the parties, my lord.
No.
That my lord binds. Because ultimately the decision, my lord, rightly passed, wrongly passed, it was passed, remain unassailed. So it's my lord now final. Now attend the finality.
but today, as far as this court is concerned, I'll be bound by the decision of PAM developers.
But my lord, that is only with regard to whether it has to be hard in my lord, commercial or non-commercial. It was said that it is better to transfer in the commercial. So right now in the commercial, it has been transferred, my lord, it has to be hard, my lord. Because so far as the parties are concerned, my lord, the impact of my lord precedent. My lord, a precedent is binding on a so far as the judgment of the division bench passed in this matter, that is binding between the parties.
No.
Whatever order has come later on, my lord, even that alters the entire law, alters the entire situation. Then also, my lord, inter-se party dispute, my lord, remains, and my lord, it has to be decided afresh, my lord. Your lordship will find that even the earlier order which was passed under section 34, I was to some extent, my lord, able to convince that was also passed in violation of, gross violation of, my lord, the settled proposition of law.
But that
Your
is
lordship,
different
give me
issue
15
because
minutes.
section 34 has already been decided. A comprehensive order has been passed. Now he cannot reopen that issue because already this
Lord, this is a fantastic argument which has been made.
Now, my learned friend is saying.
Lord, an order which has been set aside, rightly, wrongly, it has been set aside. Now that order cannot be retrieved now. It has attained finality so far as the parties are concerned. That cannot be retrieved. I can understand, my lord, today order is passed by the Honorable Division Bench, tomorrow the law may change. But that, my lord, does not put the clock back to that situation. That will not put back this issue because my appeal was there. In that event, my appeal has to be heard afresh because I have real merit in that. Lord, the single judge in section 34 has decided the matter on the premises of a legal position which was, my lord, prevailing under the 1940 Act, not under the 1996 Act.
All right, argue.
Yes,
on the merit of it.
Yes. My lord, since, my lord, first, my lord, the point of prejudice, my lord, I was told that the best point is trying to prejudice. What my learned friend is trying to do, my lord, that as if they are, my lord, traveling from pillar to post. Order has been passed such and such, but it's not like that. But kindly take up the list of dates. Before taking the list of dates, my lord, kindly note, there were, my lord, 25 claims. Out of that, my lord, 15 claims were allowed, 9 claims were rejected, and 1 claim was withdrawn. Now, out of that 15 claims which were allowed, we have paid 4 major claims. during the pendency of section 34 because it was found that it is payable. So, my lord, my client has taken a very fair and stand even during the pendency of that section 34, that 4 claims were paid without prejudice to the rights and contention of the parties. Therefore, the rest of the claims which are today, my lord, we are assailing, those are really not payable under the contract and was awarded in, my lord, gross disregard to the settled provision of law. That is why only that portion. It is not that he is deprived in entirety. The maximum chunk of payment has been made. Now, I am also a government company, my lord. IRCON is a government, central government organization. Therefore, your lordship can take up this order of 17 March 2010.
You have challenged the award partially.
I have challenged the award partially.
May I submit? He has challenged the entire award. Subsequently, during the pendency of this application under section 34. Now, Judge Sahib bolche partially challenge.
My lord, I have challenged the entire award. During the pendency of section 34, I have cleared 4 claims. I have made payment of 4 claims without prejudice to my rights and contention, my lord. That was under this order, my lord.
In this section 34 itself.
In this matter itself, my lord. My lord, earlier the number was AP 142 of 2006. So this order dated 17th March 2010. An application has been made by IRCON Limited for setting aside the award passed by the learned arbitrator dated such and such. At the outset, Mr. L.K. Chatterjee, learned advocate appearing on behalf of IRCON, submits that the petitioner is not challenging the award which was made and published on ATO in respect of the amount awarded corresponding to claim number 1234. The amounts awarded on these claims, according to Mr. Chatterjee, aggregates to 5,06,000 such and such. The interest element on the aforesaid such and such amounts to such and such. Mr. Chatterjee, upon instruction, submits that his client is ready and willing to pay the aggregate amount of rupees such and such in full and final settlement in respect of these claims only, and that neither of the parties should have any claim or counterclaim challenging the award in respect of claim number 1, 2, 3, and 4, along with the accrued interest. Mr. Royal Learned Advocate, Mr. Basu Learned Senior Advocate, submits that on behalf of the respondent, that the interest amount which has been calculated in such and such needs to be calculated. It was calculated. Mr. Chatterjee further submits that in order to reduce the interest burden of the petitioner, has been advised to admit the dues and to higher interest. The contesting parties are on agreement that the petitioner would pay rupees such and such after making requisite statutory deduction under the Income Tax Act to the respondent, evidencing such and such, my lord. And the petitioner will be absolved from making further payments on claim number 1, 2, 3, 4 in respect of. Thereafter, my lord, the other claims, after making the payment, the petitioner in favor of such and such, after receive such payment, both the parties will preclude from challenging the award from 1, 2, 3, 4. So today, my lord, the scope reduced out of the 19, out of 15, no? No, out of the 15 claims which were allowed, 4 goes. Remaining 11 are now the subject matter. The settlement, kindly note that, my lord, the settlement, however, will be without prejudice to the rights and contention of the petitioner and the respondent in respect of other claims being such and such. Therefore, my lord, enough, my lord, my client has shown bona fide, and whatever was payable under the contract found to be, it should have been honored, my lord, that has been honored. Now the entire claim which this is claiming, that is, my lord, beyond the contract. That I will show. Well, since the matter, my lord, pertains to 1987, my lord, I have prepared a, my lord, short list of dates, because the interplay of 3 acts, one is under the 1940 Act, then the inception of 1996 Act, and during the pendency of section 34, this 2015 Act came. So all of these has specific connotation, my lord, in the facts of the case. If your lordship kindly takes up the list of dates, my lord, once. On February 1987, the tender was floated, my lord. The letter of acceptance was issued in the September 1987. The agreement was entered into during 1988. Now the work was supposed to be completed within 18 months. Now that was extended for 6 months, and ultimately it was concluded in September 1989, that is after 24 months. Now, next point is very important. The final bill prepared and signed by the claimant on 1/9/1993. Therefore, September was the completion date. Now in the year 1993, September, they have signed the final bill. Thereafter, again, they have signed a duplicate copy of final bill was signed by the claimant on November. Then, my lord, 12/6, that is the, my lord, I will say, my lord, this is the commencement of the dispute. The work was concluded in 89. After 7 long years, the final bill was drawn up. Final bill was ready, they have signed, drawn up. but there was a delay in payment because, my lord, it was a back-to-back contract. We have got contract from railways. Thereafter, we have given to them. So there was a delay in this payment. So after 7 long years, my lord, for the first time, on 12th June 1996, they have made some additional claims. And those additional 11 claims are the subject matter of my lord, challenge today, which is not finding place in the final bill. It was not included in the final bill. Because there was a delay in payment, they have raised all these claims after the 7 long years, and some of which are patently barred by limitation also. Now, my lord, thereafter, my lord.
So what happened in 34?
My lord, initially in 34.
The award?
Yes, my lord. Award earlier, my lord.
See, award is passed in 2005.
Yes.
You challenge the award.
I have challenged the award under 1996 Act because.
Yes, in 2011 you have challenged the award. 2006 you have challenged the award. What happened after that?
After that, my lord, one important development is we have paid 4 claims, and thereafter the.
All right. What happened to the rest of the award?
The rest of the award, my lord, was upheld by earlier. Was upheld earlier.
Was upheld in 34.
In 34.
So you lost in 34.
I lost in 34, preferred an appeal.
4 as well as the other claims also. So everything you
4
lost.
I have said.
That's
all.
Right.
Yes,
So
yes.
You have conceded 2 and the rest you lost.
I have lost.
Then what happened?
Then I have preferred the appeal.
Then you preferred
Initially it was heard by the Honorable Division Bench of my lord I.P. Mukherjee.
Right.
We have got a stay.
So this is the order which you have shown in appeal, right?
Yes, yes.
Where the matter has been remanded back to the single judge. To
Yes.
decide whether the award is right or wrong.
Right or not.
Now come on the award.
Yes.
Where's the award?
Lord, therefore, my lord, in the list of dates, my lord, kindly note one thing. I am coming back. Lord, the Arbitration and Conciliation Act 1996 has come into effect on 16th of August 1996. And this particular reference, Section 21 or invocation of arbitration, has taken place on November 1996. Therefore, the invocation was under the 1996 Act. And the entire proceeding has to go up as per 1996 Act. Now, my lord, out of these 11 claims today, my lord, the maximum troubling claim for my client is claim number 24. This 24, my lord, pertains to interest, awarding of interest.
Interest on aforesaid claim?
All the claims. Yes. Now, this interest, my lord, I am assailing on 2 scores. Number 1, the contract said no interest can be paid. The learned arbitrator proceeded on the basis of certain case laws, which was governing the field under the 1940 Act. And at that, yes, my lord. Before that, my lord, I will join another thing, my lord. My lord, there was 2 arbitration proceedings were continuing between both the parties. Same parties, 2 different contracts. One was railway contract, another was airport contract, but the conditions were similar. The same arbitrator was appointed. Similar fate was there. And after challenging the section award in both the matters, arbitrator awarded pre-reference interest, pendentalite interest, and post-reference interest.
I am sorry to interrupt. No pre-reference interest has been made. My learned fish should
see that.
Yes.
So pendentalite interest and post-interest. So in both the matters, similar prayers were allowed, interest were accorded. Now both the awards were challenged under different section 34. One section 34 is this one, my lord, which had, my lord, gone for hearing before the Honorable Justice, my lord, earlier Krishna Rao. And another section 34 between the same parties out of the same contractual clause that went to, my lord, Justice Mousumi Bhattacharya, as his lordship was there, as our lordship was there. Now in that matter, my lord, we have won. The entire interest has been set aside. But in this matter, my lord, the entire same fact, same contractual clause, different fates were received in 2 section 34s. They have not challenged that particular section 34. I will obviously, my lord, refer as a precedent that judgment also, which says that interest should not be, because almost under the identical facts that was passed. But here, my lord, we have initially lost. After appellate court, it has now, my lord, remanded the matter. Now, if your lordship kindly straightway comes, my lord, to the award.
Page.
Lord, your lordship will get the award at page number 337.
335.
ঠিক আছে, 337 থেকে শুরু হচ্ছে। Since I am starting with Milord the last claim, that is 24.
আর আমরা আপলোড করে নিতে একটু বললাম।
এখন বলবো মাঝখানে, এটা মাঝখানে।
$337, huh?
Yes, it starts from 337. Your lordship straightway kindly comes to page number 405.
Handle with care. These are all old.
Yes, Milord, it's
Anything will come out.
almost fragile. We have, in fact, in the appeal court, Milord, in getting the documents, we were not there earlier in the section 34 proceeding. We are briefed in the appeal only. And Lord, that I should point out, we are yet to file that Vokalatnama in the 34. But we will do that. And my learned friend has also not filed. Though kichu file kon CIS kichu dekhachhe na. CIS is not
So this is the award relevant page.
Page number 405, Milord. Deals with claim number 24. That is the claim of interest. Milord, claim of interest, your lordship knows it's a parasitic claim because the existence and success of this claim depends on the other claims. Those other claims I am also assailing, saying that those are not payable under the contract, specifically barred. So before that, kindly see claim 34. This claim has been made by the petitioner for pendentalite and future interest on awarded amount at the rate of 18.5% per annum. The claimant contended that clause 16.2 of GCC has no application for recovery of pendentalite and future interest, in support of which the claimant has relied on reported decision of 1996 AIR SCW 381, Milord, that is the 1940 Act. Under the, I will show that 2003 to ABLR such and such and AP number such and such in the High Court of Calcutta to submit that clause 16.2 of GCC has no application for the award of pendentalite and future interest. Therefore, the claimant is entitled to award of pendentalite and future interest on the total awarded amount. The claimant contended, relying on section 21 of the Arbitration and Conciliation Act, that date of commencement of proceeding may be taken as the date of commencement of pendentality interest, which is 27th November 1996, in the instant case that continue up to the date of realization. In regard to percentage of interest awarded, the claimant contended, relying on section 31(7) of the Negotiable Instrument Act. Milord, I have searched the Negotiable Instrument Act. 31(7), Milord, doesn't deal with any interest. Perhaps it's a misprinting. 31(7) of the Negotiable Instrument Act, my learned friend can enlighten on it. That rate of 18% interest on awarded amount has been recognized in the said statute. Therefore, the award can be made accordingly. The respondent has contended, relying on AIR 1992 Supreme Court such and such, in view of the express provision of 16.2 available in the contract, no award of pendentalite interest can be allowed to the claimant. The respondent has also argued that rate of interest at the rate of 18% is too high. So the arbitrator, even if future interest allowed, rate should be reduced substantially, keeping in view of such and such. The claimant in reply has distinguished AIR 1992 Supreme Court 732, clarifying the subsequent judgments of the Honorable Supreme Court and the Honorable High Court, established that unless, my lord, kindly mark this portion. So on this basis, my lord, I had lost this. Established that unless specific bar available in the arbitration agreement to award pendentalite interest, said interest cannot be said to be a bar under clause 16.2 for awarding pendentalite interest. After considering pleading of the parties, arguments, case laws, such and such, I am inclined to award the pendentalite interest. Milord, now under the 1940s Act, Milord, there was no provision, Arbitration Act. There was no provision akin to section 31(7). And in that context, the law which was, Milord,
Why are we getting into 40 Act?
Yes, ma'am.
Why are we getting into 1940 Act?
No, because the
proceedings have started.
established principle which has been said here, that unless the arbitration, unless the agreement specifically bars the award of interest by the arbitrator, award will be given. That was the law under 1940s Act. Because at that point of time, Lord, 31(7) was not there. not in force. If your lordship kindly takes up, my lord, the Arbitration and Conciliation Act once, the Act of Arbitration Act. না 48 না 1996 active হচ্ছে Lord,
Yes.
31(7)(a), unless otherwise agreed by
31(7)(a).
31(7)(a), unless otherwise agreed by the parties, where and insofar as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money, for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. Therefore, 31(7)(a) starts with the rider that unless otherwise agreed by the parties. Therefore, 1996 Act under 31(7) gives a specific provision that if the parties agree that interest will not be payable, then the interest should not be payable under 31(7)(a). Now, my lord, kindly come to my particular contract clause which prohibits the interest, my lord. That is, my lord, at page number, my lord, 90. Page number 90. Page number 90 of the, my lord, section 34.
Page number 90
of the section 34 application. My lord. 90.
So this is your agreement.
Contract.
Yes.
That 16(2).
No interest will be paid.
No interest will be payable upon the earnest money or the security deposit. Next is important, or amounts payable to the contract under the contract. Therefore, the particular agreement prohibits the payment of interest against any amount, be that security deposit, be that earnest money, or any other amount to which the contractor is entitled to. No interest, and that will not specifically attracts the 7(a) first rider. That is, unless the parties agree otherwise, the arbitrator can award interest. So that exactly this particular clause was, my lord, scrutinized by the Honorable Supreme Court in an arbitration matter, and it was held that the same clause, it was the railway clause. I will read the particular clause itself. The same clause had failed judicial scrutiny, and the Honorable Supreme Court has held that no, if that clause is there, no interest whatsoever can be paid by the arbitrator, because the arbitrator is a creature of the, he emanates all its authority from the agreement. He cannot travel beyond the agreement. So your lordship kindly takes up that judgment once. Ma, first judgment down. And I will show that how the law evolved and changed. Earlier, it was said that arbitrator has to be a clause has to be incorporated in a contract saying that arbitrator shall not have any right to impose interest. Only then arbitrator's hand would be tied. Otherwise, arbitrator can give that. But there was a paradigm shift in the 1996 Act because of the 31(7). That I will come. But first, the case law 2022, Volume 2, SCC 331. Union of India versus Manraj Enterprise. Now, give me one. Eito. Eta দিয়ে দাও। Okay.
There are 30.
Lord, I would like to read some more paragraph because it contemplates the clause also. The same and identical clause, word by word. Paragraph 1, the feeling aggrieved and dissatisfied with the impugned judgment dated such and such, whereby the division bench has dismissed the said appeal of the appellant.
Which para, sir?
Paragraph 1 minute from the subject matter, only to show the subject matter.
Yes, feeling agree.
Yes. Feeling aggrieved and dissatisfied with the impugned judgment and order dated such and such, whereby the division bench of the High Court has dismissed the said appeal of the appellant and has confirmed the order passed by the learned single judge, affording the award of interest by the sole arbitrator. The Union of India has preferred the present appeal. Number 2. That contract was entered into between the appellant and the respondent with regard to 3 work contracts. A dispute arose. After 4 lines, the learned sole arbitrator vied an award dated such and such, awarded an interest of such and such. The learned arbitrator also awarded pendentalite and future interest. Kindly mark, both award was given, pendentalite interest and future interest was awarded by the arbitrator at the rate of 12% and 18% respectively on the entire awarded amount except the earnest money deposit and the security deposit. That Union of India preferred an appeal under Section 34 of the Arbitration and Conciliation Act, challenging the award made on Claim 5, by award dated such and such, pertaining to pre-shoot, pendentalita, and future interest awarded on the balance due payment from the due date of payment. The learned judge of the High Court dismissed the said appeal. The matter was carried in Section 37 by the impugned judgment and order. The division bench of the High Court has dismissed the said appeal and has confirmed the award made by the learned arbitrator, awarding pendentalite interest and future interest. Now, my lord, the next para quotes the clause. Sri M. K. Nataraj, learned additional Solicitor General appearing on behalf of the Appellant Union of India, has vehemently submitted that, as agreed between the parties and as per clause 16.2, my lord, the same clause 16.2, because it derives from railway contract. 16.2 of the general conditions of contract governing the contract between the parties, there was a bar against payment of interest. It is submitted that, as agreed between the parties and as per 16.2, no interest, kindly mark this portion, no interest shall be payable upon the earnest money or the security deposit or the amounts payable to the contractor under the contract. Therefore, identical wording like our contract, my lord. The same clause was fallen for consideration. It is urged that even under Section 31(7)(a) of the 1996 Act, unless otherwise agreed between the parties, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money. It is submitted that if there is an expression agreed between the parties governing the contract that no interest shall be payable, parties are bound by such an agreement, and no interest, either pendentalite or future interest, on the amount due and payable under the contract. It is contended that present case, so it may be a possible argument of my other side, therefore this takes care of that also. It is contended in the present case the 16.2 of the GCC governing the contract between the parties specifically bars payment of interest not only in the earnest money or security deposit, but also upon the amounts payable to the contractor under the contract, any amount. It is urged that since the parties are governed by the contract, the arbitrator proceeding are creatures of the contract, they cannot traverse beyond what has been contemplated in the contract. It is further submitted that the power of the arbitrator to award pendentalite interest consider perimetria clause to clause 16.2 of GCC has been examined by a 3-judges bench of this court in Union of India versus Bright Power Project. It has been specifically observed and held in the said case that, in view of the specific contract between the parties and the bar for awarding the interest, the payment of interest was not permissible even on earnest money deposit or security deposit or amounts payable to the contractor under the contract. It is submitted that the expression amounts payable to the contractor under contract is wide enough to cover every payment of amount payable under the contract. Look, it's a sweeping clause. It takes into its ambit everything. Thereafter, my lord, Garg was also on the same point. I'll only cite that without formally taking your lordship to the paragraph. Paragraph 4. The present appeal is vehemently opposed by such and such. Their contention was that, my lord, if your lordship reads, it is submitted that if entire clause 16 of the GCC is read, it is evident that it pertains specifically to earnest money and security deposits, and the same can in no way be read in a manner to imply a bar on pendentality interest or other amounts as contended. So, my lord, the other side perhaps has tried to impress upon the judge on the ejus dem generis principle. Since some particular words are given, security deposit, earnest money, so the other money should be construed like that. But Supreme Court has not accepted that, my lord, proposition and held, my lord. It is submitted by a 5-judge bench in this court that Irrigation Department versus State of Orissa GC Roy and had an occasion to consider the question of power of the arbitrator to award interest pendentalite, and it has been held that when the agreement between the parties does not prohibit grant of interest and where the parties claim interest and the dispute has been referred to an arbitration, then the arbitrator does have the power to award interest. Then, my lord, your lordship, stated paragraph number 6.2. 6.2, my lord, exactly here it is quoted. 6.2, paragraph 16.2, no interest will be payable on the earnest money. I am not reading, my lord, because that was earlier said. No interest will be payable upon the earnest money or the security deposit amount payable on the contractor under the contract, but the government security such and such. Then, my lord, the expression money due has been, my lord, considered on 6.3. The scope of expression money due under the contract has been considered by this court in state of Karnataka versus such and such. It was observed and held as under. What the full bench has failed to notice is that even though the damages become payable on account of breach of conditions of contract, the liability to pay damages does not fall outside the terms of the contract, but within the terms of the contract. Therefore, damages are also covered. The words any amount that may become due to or payable by the first party to the second party under the part of this agreement have to be read in conjunction with the earlier portion of the clause stipulating liability on the party contracting with the state to pay damages for breach of condition. Therefore, it follows from the damages become payable on account of breach of condition of the agreement, they nevertheless constitute amounts payable under the contract. That is under one of the terms of the contract imposing liability to pay damages or breach of conditions. To illustrate this position, if the agreement provides for a liquidated sum being paid as a damages for breach of condition instead of sum to be assessed by the deputy commissioner, it cannot be said that the specified damages will not be money due under the contract, and hence the damages cannot be recovered under the revenue recovery code.
All right, so it's very clear that unless until there's a clause, interest can't be awarded, right?
Now, my lord, thereafter, the judgments which the learned arbitrator has considered, your lordship will see paragraph 8. Ombika construction has been distinguished. And my lord, Port Authority has also been distinguished. Then Saeed Ahmed has been decided. So, this is, and kindly, my lord, take paragraph 9 once, my lord.
Yes, right.
In Garg Developer Builders, the court observed and held that the decisions of the court in Ambika Construction, where it was held that arbitrator has to be specifically debarred, and Raven such and such, relied upon the learned senior counsel appearing on behalf of the respondent therein, shall have no application. Kindly mark this. Shall have no application as the same were under the Arbitration Act 1940. It is not in dispute that in the present case the parties are governed by 1996 Act. Therefore, all the propositions of 1940 Act will straightway will not be applicable. And what I am also relying paragraph 11, your lordship has already gone through perhaps.
This is the paragraphs.
Paragraph 11, paragraph 9, paragraph 11. Agar paragraph gulo bolo. I have relied on paragraphs 1, 2 in entirety, 3, 4, 4.2, 6.2, 7, 8, 9, 11, and 12. 11, 12 and 14, 15, 16. Basically, the entire judgment, my lord, it's exactly pat on the point. And in fact, my lord, this particular case, my lord, takes care of all these 1940 Act judgments also. Therefore, my lord, this is, my lord, and my lord, kindly, I have at the very inception, my lord, I have pointed out this deals with both pendentalite and future interest.
So that judgment of Justice Bhattacharya based on this?
No, it was not raised on this, but Justice Bhattacharya found that there was since the contract prohibit, these cases are not decided. The Justice Moushumi Bhattacharya judgment not. আমাকে ওইখান থেকে দিতে হবে পেজটা।
Next, with judgment. But that takes care of only your interest part.
Interest part.
Claim 24.
Yes, interest, my lord, today, my lord, the interest amount is, my lord, mounting and the rest amount is not very much.
To pay the rest?
My lord, on that I am also coming, my lord. Those are also, my lord, specifically barred. The rest amounts are also specifically barred. Some payments which are specifically mentioned in the agreement that has to be paid by the tenderer, that has been awarded. And my lord, that also, my lord, after 200 numbers of sittings.
200?
Lord, there are 200 number of sittings.
216 sitting.
200 after 200 Lord, for 7. But I don't know whether my learned friend was materially, my lord, instructed. Perhaps we are not the beneficiaries of those 200 sittings, my lord. We are at
So it goes to show that 216 sittings.
Yes, at the cost of public money.
I will show whether it's at the cost of public money or not. Let him complete.
Yes, yes, obviously. You will
I
get
will
your
show entire aspect, entire scenario.
আচ্ছা এর মধ্যে তুমি এই জাজমেন্ট
It's not so easy what my learned friend is submitting right now.
আপনি কি একটু বলে নেবেন তারপর আমি বলবো আমার তো পাবলিক মানে কোম্পানি তো সেই জন্য আর কি
Next.
Yes, my lord. Now, my lord, Justice Moushumi Bhattacharya's judgment, my lord. এটা আমাকে একটা কপি ওইখান থেকে দিতে হবে, হ্যাঁ মার্ক করা ছিল আমার, হ্যাঁ।
I can discharge the rest of the board. This will go on. Which one is your, Mr. Banerjee?
I had actually a series of matters.
And Mr. Pandey, you have a lot of section 9.
Yes, but I have called out the ones which I will be telling your lordship to consider and the ones which I will be doing it.
Circuitous way of getting your unilateral awards.
I have already made a list.
So better be careful about that. If I find you on the wrong footing, now I'm going to impose cost on these filings.
That is the reason. That is the reason.
But not today. So be absolutely candid about the ones which are unilateral appointments. Don't try to come in section 9 in those petitions.
That's why I made 4 categories. First thing I would have told
Well,
you.
in fact, my lord,
Yes.
we have another
While
matter
reading the
fixed
file, I
at 4
realized
o'clock.
that,
জানি না কি হবে।
it's a very smart way of.
No.
But we have another matter fixed at 4 o'clock. So, anyway, since I have started, my lord,
Until 4.
yes, yes.
Yes.
My lord, in your lordship can see earlier one, our one was 141 and this is AP 141. Our one is 142 and this is 141. The judgment which I have given, my lord, Justice Moushumi. It was similar, my lord, between the same parties.
Arbitration.
Yes, 2 arbitrations. So in that, my lord,
This is 141. That one is 142. So this one
No,
is
no.
142. The one which we are hearing.
yes, that is 142 and
this is
the
141.
Justice Moushumi Bhattacharya 141. ঠিক আছে, ঠিক আছে, হ্যাঁ ঠিক আছে, ঠিক আছে। My lord, here
You were still there.
Yes. In that matter, I was.
You're like. You've been sticking to the.
Get our gown that time.
He's sticking to the brief.
এরকম judgment কি?
কুড়ি দিয়ে
হ্যাঁ,
দিলাম, 2006 পাইলো।
না না এইটাতে ছিল। My lord,
Mr.
in
Saab was
our
very,
case,
very helpful when I was sitting on the electricity, determination. He literally has the entire TAC and the.
No, no. I've tried my level
Lord,
best.
Lord,
Yes,
Lord, he used to taught us law in law college. Lord, perhaps he doesn't remember me, but he was one of our teachers, Lord.
Me
In Department of
arbitration,
Law.
in arbitration.
Arbitration.
And we always won.
So, Lord, here the interest claim is claim number 24. And in Justice Mousumi Bhattacharya's judgment, Lord, the interest claim was Mousumi judgment কত নম্বর claim ছিল বলো? 770, 75. Claim number 18. If your lordship takes the paragraph 14 of that judgment, এখানে দেখো তো paragraph 14 কত নম্বর internal page number দেয়নি না নেই দেয়া the claim number 18 related to interest. Your lordship has got that? Yes. The respondent paid for pendentality and future interest on the awarded amount at the rate of such and such. According to respondent, clause 64.5 of GCC had no manner of application in connection with this claim and relies on section 21 of the 1996 Act. In connection with that, the date on which the arbitration was invoked would be the date of commencement of proceeding, which is to be taken as the date of commencement of light interest, such and such. The same, exact same language, my lord, has found in our doc. Comments from the date of such and such until the date of realization of the amount. On the other hand, it was petitioner's position that the petitioner's position that by reason of clause 64.5, pendentality cannot be awarded, and further that the rate of 18% such and such. Similar, same argument was advanced by the parties. It's copy paste. Then paragraph 16. In a nutshell, arbitration has given the reasons for the award in relation to such and such. If reason falls short for the claim of interest, however, no reason has been given by awarding pendentality interest to the respondent number at 12% per annum from such and such to the date of such and such. The requirement of ineligibility and adequate reasoning has been settled in numerous decisions of our Supreme Court and High Court and has been found to be mandatory in 31(3) of the providing reasons in mandatory obligations unless parties. Also, several decisions have understood in resonance of the customary difference of pleading as held in state of West Bengal versus Bharat such and such, as long as there is a logical link between the manner in which the facts and recorded of the decision on such and such. Then, my lord, the full expression 2019 judgment was, my lord, relied on, and ultimate finding is in paragraph 19. Paragraph 19. Ombika.
The last.
Yes, Ombika was considered.
So it is held that cannot curb the arbitrator's power to grant interest. But here in this particular case, total absence of reasons either by way of adjudication or the quantum of interest.
Exactly. Basically, at that point of time, this judgment was not there and not relied on. But for the same, both the awards are not identical and
It was there.
no, relied on, not relied on.
No, not relied.
Not relied on. This judgment is of 2022. It is Guri's judgment. My lord, it is a judgment of 22.
Per incurium.
Yes.
It's a judgment of 22 and that's what a judgment of 20.
This judgment is also par income. I will show that.
Yes. Acha. My lord, next, my lord, is 2022 11 SCC. যেখানে দেখছিস আমি এদিকে নেব না এটা দেখে নি আগে ওটা দেখে নি ছেড়ে দে ওকে আসতে দে তোকে আসতে দে নাহলে পারবি না now next my lord I will rely on I'll not trouble your lordship much because since my learned friend is going to take the point of par incursion in this judgment, my lord, I will show from other judgments also. It takes care of all the judgments. All the judgments. Now, by in so far as 22 judgment is concerned, that does not consider all the judgments. But in this judgment, everything was considered. And ultimately it is following till the Joy Prakash. 2019-17 SCC 786. My lord, I will be relying on para 2, 10, 11. Thereafter 13.4 to 17. Disputes, paragraph 2, my lord. Dispute which has travelled up to this court pertains only to the question as to whether the arbitrators could award any interest in view of clause 50 and 51 of the conditions of contract which govern the terms between the parties. The objections were filed before the High Court. A single judge of the High Court of Delhi passed an order dated such and such, quashing the award limited to the interest that was awarded by the arbitrators. The appellant preferred intra-court appeal, which has been dismissed by the division bench of the High Court, thereby upholding the judgment of the single judge. The effect is that the High Court has held that no interest is payable under clause 50 and 59. Paragraph 5. Notwithstanding the same, the clauses I am not reading, those are similar clauses. Notwithstanding the same, the learned arbitrator granted the interest by relying upon the law declared by the court in Port Calcutta, engineer this space such and such. Kindly mark this judgment, because this is the judgment which has been relied on by the learned arbitrator in our case. Your Lordship has already gone through the finding of the arbitrator in respect of claim number 24. And the case laws which were, my lord, in the, would your Lordship just take the pain of coming back to page number 405 of the section 34 once, my lord.
Sorry, which one? Page?
Page number 405 of the section 34.
Yes.
Your Lordship, 1996 AIR ACW 381, your Lordship has got. This judgment was relied on.
Yes.
Claim number 24, fifth line from the top.
Yes, sir.
1996. Now, my lord, kindly come to the judgment which I have now referred, my lord.
Yes.
Yes, that is the judgment, my lord. It's marked as 3 with number 3. Port of Calcutta versus Engineers the Space Age. That is written as 3. So if your Lordship sees, this is the judgment. That is AIR SCW. I have checked it with myself. And the alternate judgment citation is 1996 1 SCC 516. So this was considered. On the basis of this judgment, the award was passed. Now in this judgment, this particular judgment has been distinguished and said why it will not be applicable. And what is the difference under the 1940 Act and 1996 Act. So notwithstanding the same, the learned arbitrator granted the interest by relying upon the law declared by the court in Port of Calcutta versus Engineers the Space Age and following the observations of the judgment which are quoted below. I am not reading these observations. Kindly come to paragraph 10 once, 4th line from the top. In so far as the instant case is concerned, it was governed by the law laid down by Jayaprakash Associates and Case Judgment, which was in fact a case between the same parties, and in that case the court had, while construing the identically worded clause, came to the conclusion that the arbitrators were precluded from granting any interest. His another contention was that there was a difference between the scheme provided under the Arbitration Act 1940, when contrasted with 1996 Act. He argued that most of the judgments cited by the appellant, including Harish Chandra, were under 1940 Act, whereas in the instant case, award was passed under the 1996 Act. He also referred to certain recent judgments which have been rendered by this court, touching upon the very aspect. The precise manner in which he structured his argument are recapitulated below. In the first instance, the learned senior counsel pointed out that even the arbitrators accepted on the interpretation of GCC 40 and 50 and 51 that case clauses deny interest to the appellant's due by the respondent due to dispute, etc. Notwithstanding the same, the majority opinion awarded the interest relying on the judgment of this court in Port of Calcutta. In our case, also Port of Calcutta. The learned single judge of the High Court, while reversing the aforesaid view, pointed out that 1996 Act had altered the position contained in 1940 Act. Under the new Act, an arbitrator could not award pendentality interest when there was an express bar against award of such an interest. This legal position is contained in section 31(7)(a) of the 1996 Act, and the legal position stood crystallized in Syed Ahmed versus State of UP. Therefore, held the learned single judge when clause 50 and 51 GCC imposes a complete bar or arbitral tribunal to award pendentality interest. The arbitrator had no jurisdiction to award interest. Mr. Banerjee submitted that the learned single judge even noticed the judgment in Harish Chandra's case and distinguished the same on the ground that it arose under 1940 Act. Furthermore, clause 1.9 of Harish Chandra case was indeed restrictive and different from the wordings of clause such and such. On that basis, Harish Chandra judgment was distinguished.
All right, how many more judgments you have to rely upon? It's already
This much. And
No. All the judgments are not required to be read out. I only give the paragraph numbers.
He's trying to scare me.
No, I will not.
But I will make it simple.
I'll only give the paragraph numbers.
Lordship,
These similarly circumstance judgments I will not read in totality.
You have to go, or
Yes, my lord, it's better if you are
heard Mr.
Mr. Arnab Chakraborty.
Arnab Chakraborty.
Lordship, kindly then fix up and time, Lordship.
Time I can't fix, date I can.
Lordship, subject to your Lordship, kind of, because since we have-
We'll try to finish it off.
I'm praying before your Lordship.
But list for further hearing on Monday क्या है?
Lord, let it be after Tuesday, my lord. After Tuesday, Wednesday.
Wednesday.
এত টাকা পেয়ে বসে
Wednesday at 3
কিছুই পাই-
Wednesday.
Wednesday at 3 p.m. Lordship. I'm deeply obliged, Lordship.
Let's try to finish it off.
I'm deeply obliged.
Yes.
5th August.
I will not take much time.
No, he is also.
Wednesday would be Gopal. We have to
Come with a note pointing out the particular clauses which bars what claim. Because all the claims are point-wise, I will deal that this is barred by under this clause, this is barred by under this clause. And Lord, if your Lordship, Mr. Banerjee, Mr. Satoru Banerjee had mentioned the matter in the section 34 petition. Since your Lordship will hear section 34 matters, that
Your lordship was pleased to fix on next Wednesday at 3 p.m. I am deeply obliged. No, I know, I understand. No, I am not on that. I understood that.
Your lordship's list is really very heavy. Entire arbitration is 11, 29, 30.
Lordship, fix up the particular day on yes. That will be better.
And that time your lordship will find that 34 advocates are not coming.
No, I have also got certain 34 matters which cannot be placed because
Yes.
Yes,
When it
certainly.
is start. Yes.
Because they have filed a section 34, they are sitting tight with.
No, nowadays, after 34,
No,
since the
that
money
is-
has to be secured, everyone has urgency.
2015,
Everyone has
but
urgency.
prior to 2015, yes, that is the case here.
Those are.
Yes.
But it is not the case here because my learned friend has adequately been compensated
No, not
already.
yet, not.
He's,
Not-
now he's the last
I
drop
will
of
show-
blood you want to show. So
I'm deeply